Hello. Hi, the person who just came in named Judy. Can you let me know what case you're here for and what your name is? Hi there, is this Judy Duke?
It is.
Okay.
I've done this right.
Well, so far you're doing great. I just wanted to make sure I know who you were. And until it's time for the hearing in your case, I'll keep you muted, okay?
That would be wonderful, just in case the dog barks. I'm hungry.
Okay.
Thank you.
Okay, thanks. Bye.
Bye-bye.
Good morning.
Hi, Commissioner O'Brien. How are you?
I'm okay. You?
Hanging in there. Hey, Mel, is that link posted? Hello, Commissioner Davids. Hello, Commissioner Ashby.
Good morning, Amy.
Morning.
Hello, test. Hello, test. Good morning. You hearing me?
Yes, who's that?
Ed.
Oh, hi,
David.
Ed. Hi.
Good morning.
Yes, I could hear you when you were using your headphones too.
Yeah, I was confusing myself with which microphone went with the headphones and whatever, so we're all set.
Okay. Good morning, Commissioner Dusan. Can the person with the phone number that ends in 803 just let me know who you are and what case you're here for?
Amy, it's Alice. I'm just calling in on my phone while I'm waiting for my computer to catch up.
Okay, thanks, Alice.
Good morning, everybody. It's 8:30, so I think we'll get started. I'm Deb Whitworth, and on behalf of my fellow commissioners, welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I am asking each of you who may have an electronic device, and I think we all do, cell phone, pager, etc., to ensure that they're silenced now. You should have access to the agenda, including the consent agenda, on the Maine Human Rights Commission webpage, and I believe that was all sent to participants as well. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted period. The commission will vote on those cases and they will not be considered further today. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. So with that, could we have a motion to adopt the agenda and the consent agenda?
So moved.
Second.
So commissioners, I'll remind you that pursuant to our remote participation policy, we're required to have every commissioner vote in a fashion that is both visible visually and also auditorily. So I will ask each of you for every single thing we do to vote one at a time. So Commissioner, the motion is to adopt the agenda and consent agenda. Commissioner Whitworth,
Yes.
Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner Doosan,
Yes.
Commissioner O'Brien.
Yes.
Thank you.
And now the minutes. Is there a motion to approve the minutes of November 8th, 2021 commission meeting?
So moved.
Second.
So commissioners, it's been moved and seconded. The motion is to approve the minutes from November 8th, our November 8th meeting. Commissioner Whitworth,
Yes.
Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner Doosan,
Yes.
Commissioner O'Brien.
Yes.
Thank you.
And now, Amy, if you could give us a director's report, please.
Yes, I would be happy to. Good morning, commissioners. Not a ton to report since our last meeting. And you have a personnel report from me that goes over the fact that we're interviewing folks for our vacant investigator position. For compliance, you have a memo that says that we have 7 cases currently in active conciliation. Since our last meeting, 3 cases that were not successfully conciliated and 0 successful conciliations. However, there are 2 conciliation matters to discuss. One is you have a memo regarding a case that did settle just after conciliation. So it's a post-conciliation memo. Technically, probably should have been from Barbara, but it didn't get to her yet. That case is E19-0298 PV versus Burlington Fire Department, Burlington Municipal Fire Department, and I am hopeful you will make a motion to approve that post-conciliation agreement.
I move that we approve the post-conciliation agreement E19-0298.
Second.
So the motion is to approve the post-conciliation agreement in E19-0298. Commissioner Whitworth,
Yes.
Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner Doosan,
Yes.
Commissioner O'Brien.
Yes.
Thank you. The other matter in conciliation relates to a case in which the Conciliation has been implemented, so the case should be dismissed, and you have a recommendation for dismissal in E190019, Varney versus Planet Fitness. So I'm hoping you will approve the dismissal of this case.
So move.
Second.
Thank you. So the motion is to dismiss E190019. Commissioner Whitworth,
Yes.
Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner Dusan,
Yes.
Commissioner O'Brien.
Yes.
Great, thank you. So that's it for conciliation. An investigation, we received 53 new complaints in November. For administrative dismissals and predetermination settlements, the sheet that you have, which shows resolutions, shows 0 for administrative, or rather it shows 1, but that's mostly because a lot of things that were done in November didn't get put into our computer system and therefore didn't show up on the report. I can tell you that we actually, there were 7 administrative dismissals and 3 predetermination settlements, and they will end up showing up when we have updated reporting to you next month. But I just want to let you know, it's not that we're not doing anything, we're just short-staffed and things aren't always able to be inputted on time. Other than that, for litigation, I would ask that we discuss that in executive session. And I don't actually think that I have anything for new business. Usually I say that and then I remember something else in a minute, but at the moment, nothing's coming to me. So Barbara, unless you can think of something that I forgot, nope. Okay. Then I think we
Okay.
have a few minutes.
Yep. So we'll come
Amy?
back right at 8:45.
Question?
Hold on, Commissioner Ashby, yes.
I'm sorry. I hate to miss things, but you had indicated new chart. Did you report new charges in November and discuss administrative dismissals?
I did,
So
Uh,
I have a new charges report.
yes.
Um,
And you should have a resolutions report that is 1 page. And that shows a lot of zeros on it.
yeah,
And
that's
it's-
what I'm looking for. I can't seem to locate that.
Oh.
I'm sorry. No, forgive me. I found it. That's the answers my question.
Okay,
There, I'm done.
okay, brilliant. Good question. So I think we have 7 minutes till our hearing agenda starts. Is that right, Deb?
Yes.
All right, thank you.
Okay, everybody, let's come back. It's 8:45. So where we left off here. So procedural rules of the commission specify that, oh, I'm sorry. Cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium. In this case, will be called to speak on Zoom to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only 1, relevant factual errors, 2, relevant omissions from the report of facts submitted during the investigation, or 3, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that commissioners may ask questions, and I will ask that each of you introduce yourself as you are called to present your case. Thank you.
And before we start the first case, another just reminder to everybody that in the reports that we sent you, we have taken out the names of any third parties or witnesses, and we've given them pseudonyms. Please do not refer to them by name, as the Maine Human Rights Act requires us to keep the names of third parties confidential. Thanks.
Okay, and our first case is E190450, Heather Beach v. Mentor ABI LLC, doing business as Neuro Restorative Maine. Is there anybody here for the claimant? Barb, you're on mute.
You're muted, Barb.
Thank you, Commissioner. Yes, I'm here for complainant Heather Beach. My name is Barb Lilly. May I just continue?
Go ahead, Barb.
All right. Good morning, Commissioners. This case involves a failure to provide reasonable accommodation and constructive discharge. Now, please keep in mind when you're thinking about the facts in this case that failure to accommodate claims do not require proof that the respondent intended to discriminate against the complainant. Now, the investigator has recommended that you find no reasonable grounds, but we believe the investigator erred by sort of focusing in on the wrong facts. The investigator had her eyes on the interactive process instead of directly on the accommodation that the complainant requested. The evidence here clearly shows that the respondent knew that the complainant, Ms. Beach, couldn't work alone because of her disability. Accommodating her was reasonable. That was the determination of the respondent directly, and it didn't pose an undue hardship. And yet the respondent persisted in telling the complainant that she had to work alone. So a complainant did what a reasonable person would do in her circumstances. She wound up facing an impossible choice and resigned in order to avoid harm to herself or to the resident. Heather Beach, as you probably see in one of the boxes on your screen, she's intending to be here. I hope she's on her way, and she'll be sitting in that chair when she gets here. In any case, Heather was a conscientious employee who happened to have rheumatoid arthritis, which is defined as a disability per se. Just having the diagnosis is a disability under the Maine Human Rights Act. The respondent here, Neuro Restorative, is a provider of rehabilitation services and operates a number of residential houses. Ms. Beach's usual assignment was to work in house 1, where 4 or 5 residents lived. She was very familiar with the residents who lived there. One of them was a person who we called Client M in our papers, and that the investigator called Resident 1. They're the same person. He weighed about 200 pounds and was unable to stand and pivot while transferring from a bed to a chair or from a chair to the toilet. The investigators report errors, we believe, by concluding that the respondent believed that resident 1 could stand and pivot. We dispute that, but it turns out actually that this dispute is not all that important to the outcome of the case. So let's look at the chronology of events that led up to her termination or separation from employment. It's fairly simple. On February 2, 2019, Ms. Beach told her supervisor, Ms. C, I'll probably just call her supervisor, that means Ms. Beach couldn't work alone with resident 1 because of her disability. Resident 1 was just too heavy for her to lift and transfer. Ms. Beach explained that her concern was really serious. She said that she'd be forced to quit if she had to work alone with resident 1. Ms. Beach understood that her own health and safety and resident 1's rights as a client and a disabled resident were at risk if she was unable to care for him, but she couldn't care for him alone. So even though supervisor had no doubt that what Ms. Beach was saying was true, she asked Ms. Beach to get a doctor's note confirming that she had a lifting restriction, and that's fine. But still, as of February 2, the respondent should have begun providing an accommodation to Ms. Beach, at least on a temporary basis, while waiting to get her doctor's note. A couple of days later, supervisor sent an email about Ms. Beach's lifting restriction to her managers. And in her email, and I'm going to quote it, it says, "I just wanted to bring this to your attention so we make sure that her paperwork comes in and we follow up with ensuring that the restrictions get set in place so no one gets hurt." So she understood that if a person who had a lifting restriction was required to do this work, someone was going to get hurt. A couple more days later, Friday, February 8th, Ms. Beach saw her doctor and got a note verifying her disability and her lifting restriction. She asked the doctor's office to fax the note to the respondent and believed that they did. On Wednesday, February 13, Ms. Beach noticed that she was on the schedule to work alone in House 1 on Monday, the 18th. She immediately contacted her supervisor and reminded her that she had already asked for an accommodation and couldn't work alone with resident 1. So this is a second reminder to the supervisor. She needed to get someone to work with Ms. Beach. That was going to be next Monday, the 18th. Ms. Beach was told that the respondent didn't get the doctor's note, so she again immediately went to her doctor's office, asked them to fax the note over, and the respondent did get the note this time on the 14th. Now, what I'm going to tell you next is a key fact that was omitted from the investigator's report. And it's so important, I'd like to show you the exhibit while I'm reading from it. It's redacted. Do I have permission to share screen with the commissioners?
No, you don't, because I haven't seen what it is that you're talking about, and I would need to see that first.
Well, it's a respondent's exhibit from the case.
Again, I would need to see it beforehand.
Okay, so my apologies. So let me get the doctor's, well, what it is in, well, let me just pull it up myself.
And just so you know, it's not unique to you. We've had this request at other cases, and I've said the same thing in all of them.
Yeah, my apologies. I should have asked ahead of time. All right. This is from the investigator's file. It's an email from the program director to the HR director with a copy to supervisor, and it's dated February 15. And it's in response to the HR person asking the program director if she could be accommodated in the way she's asking to be accommodated. The program director says yes, she's a per diem staff. It will limit some shifts she can pick up, as this basically means she can't work alone. If someone falls, she'll be unable to assist with getting up. So this is on the 15th. The director of the program says she can be accommodated, she can't work alone. That was a third reminder to the supervisor that she needed to find someone to work with Ms. Beach on the 18th. Now, Ms. Beach didn't know about that email exchange at the time, of course, but she was keeping an eye on the schedule. And at 8 o'clock in the evening on the 17th, the day before she's scheduled to work, she writes to the supervisor, quote, "I'm still on the schedule alone. Has that been sorted out?" The next morning, the supervisor
Barb?
says, "Work."
Ms.
Yeah.
Lally, I'm sorry to interrupt you. The investigator was just wondering what exhibit number that was that you were reading from, so the investigator can make sure that they're on the same place as you.
No problem. The one that I read from is Exhibit B, I believe it's from a second submission that was made by the respondent.
They're nodding, so
Okay.
they've got it. Thank you. And I paused
Okay.
your time. Thank you.
Thank you. So the supervisor says, I'm working on it. And Ms. Beach says again, please let me know as soon as possible. I can't be there alone. She extended, and then again, there's some more text messages with the supervisor just in the few hours leading up to the start of her shift. And at that time, she's given 3 options. 2 of them are basically the same. One of them is work at house 1 from 8 to 11 p.m. and then go to work at house 3. Option 2, work at house 1 for the whole shift with a little help with help as needed if she calls over to another house and gets someone to come over to help her. Now, both of those options aren't workable because they require that she work alone in house 1 for a number of hours, something that everyone agrees that she couldn't do. The third option was about this Hoyer lift, about can he stand and pivot and work with her and with a Hoyer lift. That's why that evidence is really not that interesting or all that important, because there's no time she couldn't get Hoyer lift training before the start of her shift. It was starting at 8 o'clock and this was offered to her at 6, sometime around 6 o'clock. So here, that's what we've got, is that the important fact, and then finally, the important fact that the investigator didn't, or as far as I know, the investigator didn't uncover is who actually wound up covering for Ms. Beach when that night, that shift on the February 18. Whoever that person is someone who could have been found earlier and scheduled to work along with Ms. Beach. But it never had to get to that point in the first place. Ms. Beach had given many warnings. I can't work alone. I can't work alone. That started on February 2nd. By February 18, she's still being told you have to work alone. You have to work alone. It's just unreasonable. So the investigator's report was aired by concluding that the interactive process was ongoing, when in fact it had stopped. I mean, there was no time for it to happen, anything else to interact, anything else to happen before her shift started on the 18th. And that's what we would say, is that she needed an accommodation by the time her shift started. They knew she needed the accommodation. They knew she couldn't work alone, and yet they continued to tell her that she had to work alone. Their failure to provide Ms. Beach with an accommodation and scheduling her to work alone, given that someone could get hurt, violated the Maine Human Rights Act. And again, I want to point out that the complainant does not need to show that this was an intent to discriminate against her. I'm going to reserve the rest of my time.
Thank you. Commissioners, any commissioners, if you have a question for Ms. Lally, raise your hand and I will call on you in order. Okay, I see one. Okay, Commissioner, first Commissioner Ashby and then Commissioner David.
Attorney Lally, assuming that the restriction that she not be required to work alone was a reasonable restriction, is it possible there's some room to interpret the term work alone to perhaps include what appears to be the accommodation offered by the respondent in this case, and that is that there's someone apparently in house 2, a very short distance away, that could in fact assist the complainant if she required some assistance. In other words, I guess, is she really working alone if a few hundred feet away there's another individual she can call upon if she needs assistance to move this client?
That's a good question. That was one of the options, was that she could work alone in house 1 and have someone come over from house 2, but it was only for a limited number of hours. It was between the hours of 8 and 11. So after 11 p.m., she was not given any backup support from somebody from house 2. And this is a resident who Ms. Beach knew for a fact was somebody who uses the bathroom at night and often gets up to smoke, go for a smoke, which is maybe not very good for his health, but it's certainly his right to get up and go smoke. So those are 2 things that she was aware that resident 1 would need that she would not be able to accommodate. These are residents' rights to have assistance with toileting and for getting out of bed and getting into a wheelchair to do the things that they want to do. Second thing is that if there was a fire, of course, getting somebody out of the house when she had alone 4 or 5 residents to care for, that was not a reasonable thing to request that she do, or a risk that she should be able to take. And then again, looking at the respondent's own discussion of why she could be accommodated and why she shouldn't be working alone, is that if someone fell down, she'd be alone and she wouldn't be able to assist those people. So the fact is that she was not given the opportunity to have backup assistance from house 2 throughout her shift.
Okay, thank you.
Commissioner David, did you have a question?
Yes, Attorney Lilly, you said that there was no undue hardship to accommodate the request. Is that your determination to make, or the employer's?
It's the employers. It's us. It's an objective fact finder, but the employer themselves in this particular case agreed that it was not an undue hardship. That was the email that I was trying to wanted to show you, but then wound up reading to you. There's an email from the program director who, in answer to the question, "Can you accommodate this?" answered yes.
Doesn't that indicate that they're trying to do that? It seems to me that the crux is in the investigator's conclusion that the record reflects no discriminatory animus. Do you think there's discriminatory animus?
No, I'm really glad you asked that, because that's what I started my presentation with. And that's what I think is important. We're not saying they weren't trying to accommodate her. They were offering these options. They weren't very good options, but they were offering options. When you have a claim of failure to provide reasonable accommodation, you don't have to prove animus. It's a form of discrimination that is proven by you ask for the accommodation's reasonable, you need the accommodation, the employer, it's not an undue burden, and the accommodation isn't provided.
Who says it's not an undue burden?
Pardon?
Who says it's not an undue burden? They're understaffed and they're working with her and they're trying to accommodate.
The employer concluded that it was not an undue burden. The employer concluded that what we need to do is make sure that she's not scheduled to work alone. And the employer went ahead and put her on the schedule and didn't find someone to work with her or take her off the schedule and have someone else work there.
Okay, thank you.
Yep. Commissioner Dusan, you had a question?
Yes, I want to make sure I'm understanding the circumstances here. The employer takes the position that they were in the course of attempting to make a schedule accommodation so that complainant would not work alone, yet complainant was scheduled to work alone. If the complainant proceeded, well, I can't ask you that, but from the complainant's perspective, is she then challenged to decide to go ahead, work alone, and hope nothing happens? Is that essentially the choice presented to the complainant?
That was the choice.
Okay, I'll ask employer about it as well. Thank you very much.
Commissioners, any other questions for Ms. Lally at this point? Seeing none. Barb, you'll have about 45 seconds left when we come back to you. And then,
Thank you.
Yeah. And then I believe Mr. Herzog is here for a respondent.
Yes, thank you, Director Sneerson. Good morning, commissioners. I think I want to speak first to this February 18th shift that the complainant was scheduled for, since it seems like this is really the focus of all this. As you all know, the law doesn't state that whatever accommodation an individual requests is the accommodation the individual is going to get. It simply requires that the employer take the information, the accommodation that's requested, assess what's reasonable, assess what's an undue hardship, and work with the complainant to agree on an accommodation that is reasonable and that can accommodate the individual's disability. That's exactly what the respondent did here. It scheduled her for this shift before it got the doctor's note. The complainant even admits that. And then once the complainant notified the respondent that she was concerned that by working the shift, she would be forced to work outside of her work restrictions. Contrary to what she is suggesting, the respondent did anything but tell her, well, that's just tough luck. You're just going to have to work alone. I heard Ms. Lowley say a couple times that respondent was basically forcing her to work alone. And as I believe Commissioner David alluded to, they gave her a number of options. They offered her the ability to work at another house with somebody else. She refused that suggestion. They offered her the ability to call somebody else from another house, which respondent believes is equivalent to not having her work alone. And in fact, the day that she was scheduled to work this shift, respondent had prepared a letter stating that they would be granting her accommodation. They worked with her every step of the way. And as you can see from the text messages and the emails, there was no animus, and there was a constant regular effort to work with her and engage in the interactive process, starting from the time that she said she would not work a specific shift on February 2nd, which I'd also like to point out, when she indicated that she had a restriction back on February 2nd, the respondent offered her an accommodation on that day, which she refused. So the fact pattern at issue here, which I believe investigator Neal captured quite accurately, was that respondent repeatedly tried to work with the complainant in accommodating her. Complainant demanded one specific accommodation in the way that she wanted it and was not willing to budge or compromise on the accommodation. She wanted exactly how she wanted it. In terms of the constructive discharge piece, there was testimony, and I get the sense, Commissioner Doosan, maybe this was the question you were going to ask. There was testimony at the fact-finding conference that had she said, I'm not going to work on the 18th because of my restrictions, I'm not comfortable, her supervisor had testified that she wasn't going to be fired. There was no intent to terminate her had she not shown up for her shift. And I believe, as the commissioners know, the standard for constructive discharge is that a work environment must be so intolerable that a reasonable person would feel compelled to resign. And as you can see from the communications with the respondent, trying to come up with some way of accommodating the complainant, there is absolutely no evidence that there was an intolerable working environment. Nobody forced her to work any shift. In fact, complainant did not work a single shift where she was asked or forced to exceed her lifting restrictions. She didn't end up working a single shift where that was the case. And so, you know, we're very, we feel very strongly about the fact that we engaged in the interactive process in very good faith with her. Just a couple responses. First of all, you know, in response to complainant's statement that when respondent offered her the ability to call over to another house, which is only 100 or 200 feet away. I mean, it would take a matter of a minute to 5 minutes for the person to walk over and assist her. She said she was not given backup for a specific period of time. It was only, I believe, from 11 to 2. I don't believe that was included in the filings in this case. I would ask the commissioners not to give that any credence whatsoever. That's not true, first of all. And second of all, I don't believe that was in the filings. Second of all, in terms of standing and pivoting, I believe there's a commissioner that asked the question, could it be interpreted that, working alone, not being able to work alone didn't just mean that somebody was there with her physically in the same house at all times? Could it also include that somebody's in the house next door who is on call? It's our position that that is true. And so in any case, I'd like to stop my presentation and reserve the rest of my time to respond to Ms. Lely's response and take any questions from the commissioners.
Yes, I will hang on to your time for afterwards, but first I'll check with commissioners to see if they have any questions at this point. Any commissioners who have questions at this point for Mr. Herzog, raise your hand and I'll call on you. I do not, Commissioner Doosan?
Just thank you, Mr. Herzog, for anticipating my question. I wanted to make sure to ask you the same question regarding respondents' understanding of the scenario during the shift on the 18th. It's respondents' position that the possibility of needing to lift a resident, which I think I'm understanding that the complainant's lifting restrictions would have prevented her from doing so. The respondent's position is that would have been, you would have been able to do that by calling someone from the other house, which is just a couple hundred feet away. Yes, or you're nodding, but yeah.
Oh,
So
I didn't know. I
understand-
wanted to make sure you were
Yes,
finished with your
oh,
question.
okay. Go ahead.
Yes, I mean, that is one of the options. The other option was for her to go work at another house with someone else, so she wouldn't be working alone. But she had claimed that her father-in-law was there and that was unacceptable for some reason that respondent wasn't aware of at that time. But the other option was, yes, there in Old Orchard Beach, there are 3 houses. There's house 1, house 2, and house 3, and they're all basically next door to each other. And essentially, if she were going to be working alone in that individual house, there are other houses she can easily just call over to, and someone can just walk over and assist her if she needs it. So those were essentially the two primary accommodations. And again, as of February 18th, they had a note accepting her accommodation. It was ready to go. But one of the primary challenges that they continue to have is significant understaffing. It's well known throughout the organization. The supervisors have an incredibly difficult time trying to find staffing for these locations. And so they were bending over backwards trying to figure out how to possibly accommodate her, one, either by sending her to a house with someone else that she found unacceptable, or 2, allowing her to work the shift and then call over to another house and get assistance when needed, if she even needed it. I mean, again, the investigator's report accurately states that her position, complainant's position, is essentially just based on a bunch of hypothetical scenarios that never materialized. So yes, Commissioner Doosan, that is the case.
Thank you.
Any other questions from commissioners for Mr. Herzog at this time? Commissioner David?
Attorney Herzog, do I understand you to say that she was offered the ability to go work in a house that she rejected because of her not wanting to work in a house in which her father-in-law was a resident? Does she have the right to make that determination?
That's correct. Our position is she doesn't have the right to make that determination. She suggested that she did not want to work in the house with her father-in-law because he was not comfortable being in a house with her and that it violated his right to choose the staff with whom he was going to work, but that
Okay.
option was presented to her to work in another house with someone else present.
As a temporary accommodation.
Correct.
Thank you.
Any other questions from commissioners for respondent at this time? Okay, seeing none. All right, Mr. Herzog, you'll have about 3.5 minutes when we come back to you. Back to Ms. Lely, you have about 45 seconds. Oh, you're muted.
Sorry about that. So the first thing, and really important, is that the two options that were offered by the supervisor both involved Ms. Beach working for several hours in the house she worked in, working there alone with no help from other houses. Remember, so they're all short-staffed. They didn't have other people who could just run over and help her. It really is clear from the text messages in this case that she was being asked to work alone for at least several hours if she went to work at that shift. Now, again, we still don't know who worked for her. She didn't go to work. So somebody came in and worked for her. That person could have been found and assigned to work with her if they had started the process when she asked for the accommodation back on February 2. Again, with constructive discharge, if I do have time,
Actually,
remember
I'm sorry. I apologize. Your time is up.
That's fine. Thank you.
Any other follow-up? I'm sorry, any commissioner follow-ups for Ms. Lely? Seeing none. Thank you. Mr. Herzog, as I said, you've got about 3 minutes.
Thank you. Just to respond to that point again, there's no evidence, and it is not true that she was being asked to work alone without help, without on-call help for several hours. There were people staffing the houses adjacent to her house. Those weren't going to be unstaffed houses. People were going to be at those houses on call, ready to assist. And so that just, I don't believe that was in the submission, so I don't think we should be accepting that allegation. But at the same time, it's just not true. They knew the restriction. They communicated about the restriction, and they weren't expecting her to work in violation of her restrictions. They had their own concerns, and they were working with her from the very get-go. So that's all I have to say. So I thank you for your time.
And I think the investigator can address the question of whether that's in the record or not. But in the meantime, any follow-up questions for Mr. Herzog from commissioners? Seeing none. Okay, thank you. Then we will turn to the investigator, to Alice Neal.
Good morning, commissioners. I'm Alice Neal. I was the investigator on this case. As an initial point, I know that Attorney Herzog mentioned that there might be some information that he didn't believe was specifically in the record. And I do recall during the investigation and in the record was the thought that complainant would have possibly been alone for a few hours on the shift on the 18th, but that she could call to another house to get assistance, and that definitely was in the record. I don't think the specific hour time period of 11 to 2 was in the record, but there definitely was information in the record that there may be, and I want to say maybe, a few hours where a complainant would have to be alone in the house. And other than that, I've heard what has been presented today. I think that the parties have laid that all out. My report, I think, gives you what my thoughts are, and nothing I've heard today changes my recommendation, but I'm happy to answer any questions that you have.
Commissioner questions for Alice? Commissioner Ashby.
Hi, Alice. I guess I want to parse that out a little more carefully. I don't think there's any dispute from your report, at least, that the complainant was going to be required to be alone in the house. I think the question that's arisen, raised by me, addressed by Attorney Lely, and then contradicted by Attorney Herzog, is that the record, well, we wonder, does the record say that there is a period of time in which the employee at house 2 would not be available to be called over to the complainant if the complainant required her to do so.
Give me just a moment. I'm going to try and look at the text message string real fast for you. There is a text message between them that is from supervisor with complainant that says that the complainant would be alone and there's no one else to put her with. And that is what the text string says. I'm not seeing anything specifically about house 2 and whether or not there wouldn't be anyone at house 2. I do think that Attorney Herzog represented appropriately that the complainant could reach out and to house 2 to get help for if she needed to transfer this particular patient or any other patient that might exceed her lifting restrictions. Does that help answer the question, Commissioner Ashby?
It does, and how I vote isn't going to necessarily turn on this question or not, but Attorney Lelly indicated that the record says that between 11 and 2, there will be no one in house 2 to be able to assist the complainant, and that seems to be one of the stronger arguments that respondent is making, that is a reasonable accommodation, that she's not technically working alone if there's someone in house 2. And I'm not sure your answer answers that question. Attorney Herzog indicated that the record is silent as to that question.
I don't think that I have information about house 2 and who was in house 2 at that time, but I mean, and from a logical standpoint, it seems illogical that there wouldn't be someone in house 2 if there are residents who were going to be there. Then again, that's just my hypothetical thinking about it, and so I don't want to necessarily impart that into what your question is.
Thank you.
Commissioner David and then Commissioner Doosan.
Good morning, Alice. You say near the end of your report before the recommendations in the 3 paragraphs up, ultimately, when complainant realized that coverage could not be arranged in a manner that met with her approval, she resigned. Do you still stand by that they were, I mean, the implication there is that they're trying to work with her, but she's making a demand that she doesn't find appropriate and that she then resigns. Is that correct?
I do still stand by that statement, yes.
Okay, thank you.
Commissioner Doosan.
Hello, Ms. Neal. Thank you for another excellent report.
Can you speak up a little bit?
Yes.
It's hard to hear you.
Hello, to the investigator. Thank you for another excellent report. I couldn't tell from the materials whether your investigation included a review of the staffing requirements for this level of care in a facility. Mr. Herzog mentioned the term unstaffed house and asserted there were, and throughout the discussion, it's been clear that the other houses were staffed. Did you look at the minimum staffing requirements for these facilities? It would seem to be important to know if one called, if all of these facilities have a single staff in them for this overnight shift, if you called for help to be facility number 2, which would then leave that facility unstaffed, you create the same problem that it seems the concern that complainant is arguing is evident, is present in the house that she's working in, which is that if she can't lift, then essentially the house is, if there's an emergency, the house is not staffed with someone who can respond.
I did not look at that specific piece because as part of the record in the investigation, it was that the houses generally always had 2 people that were working a shift. And so I took from that that there were generally 2 people who were working a shift, but that the other underlying piece in all of this was all of the gross understaffing that had been the ongoing issues for respondent, and being able to put those 2 together, that generally speaking, there were 2 individuals that were supposed to be in the house, but the respondent was having a hard time with their staffing. So to answer the specific piece, no, I did not look at it because of the other facts that were in the record.
Okay, thank you.
Any other commissioner questions for Ms. Neal? Seeing none. Okay, thank you, Alice. So commissioners, you've heard from the parties and the investigator, and at this time, we would be looking for a motion or motions. Commissioner David.
Excuse me. I'll move that there are no reasonable grounds to believe that respondent discriminated in employment based on her disability, and take 2 with it that there was no retaliation.
Second.
I'm sorry, was that Commissioner O'Brien?
Yeah.
Thank you. So it's been moved and seconded, no reasonable grounds on both claims. Is there any discussion?
Well, what's determinative for me is I go back to that fact that they're generally understaffed. That's not a condition that we know that they're dealing with, that they're working with her, that there's no animus, that they're trying their best. And I can't conclude that that results in discrimination, because it doesn't work out exactly the way complainant demands that it be, and she instantly resigns. So I have to give the benefit to the investigator's conclusion on that, which seems reasonable.
Any discussion, further discussion from commissioners? Seeing none. So the motion is to find no reasonable grounds on both claims. And if you vote yes, you're in favor of that motion. Commissioner Whitworth?
Yes.
Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner Doosan?
No.
Okay, so you're voting no, so you're not voting yes. Okay. Commissioner O'Brien, so the current motion is no reasonable grounds on both?
Yes.
Okay. So the vote is 4-1, 1 vote not in favor of the motion. And so both findings are no reasonable grounds. And with that, we're actually going to, and thank you to council for being here. We're going to move up a case that was intended to come a little bit later, but we have council with some personal obligations. So we're going to move it up. The case is PA 20-0057. It's Caterino versus Northeastern Motel. Alex is here, and I believe Attorney Hoffman, I believe is, yep, on there, and Mr. Doyle is on there. Okay, and we appreciate everyone's patience as we move cases around. Normally we don't, but in this case, we're going to. And even the chair did not know that. Surprise. Nope, you're muted.
This is a reasonable grounds recommendation, so we would like to hear from the respondent first.
Thank you. My name is Peter Doyle. I'm here on behalf of the respondent. Three Shakes LLC, and they do business as Northeastern Motel, which is how they've been referred to in this matter. We became aware of this matter February 13, 2020, with a notice which, among other things, required a non-disclosure agreement to be signed in order to fully participate in this matter. The respondent replied within the time allotted and provided the non-disclosure agreement. Without going through the entire matter, they did disclose that this complainant made two separate stays at their hotel, the first for 1 night and the second for 7 nights. There were numerous disputes with what the complainant had to claim. That's in the record. There was a third-party affidavit which confirmed that the complainant had been the instigator of an ugly public dispute that involved both vulgarity and racist comments on his part. To date, despite the non-disclosure agreement, the respondent and counsel have yet to receive a single document which would indicate that except for the conclusory comment in the investigator's report, there has been no evidence or document submitted to us which would confirm either a disability or the service nature of his animal. Of significance in the initial papers, the complainant claimed that he provided a doctor's note to the respondent manager. And in our papers, the respondent manager confirmed that while he did come in with a piece of paper in his hand, yelling and gesticulating in what is a very small office, he never offered any paper to them. They never received a paper. And it is only a representation that that was a doctor's note. It was never provided to the respondent. Again, on May 18, 2021, the investigator requested and gave the opportunity for the respondent to respond. The deadline was June 8th. The respondent, for all parties, the respondent replied by June the 4th. The complainant did not respond, or at the very least, the respondent did not receive any copy of a response from the complainant, which the respondent was entitled to. Evidently, Maine Human Rights Commission extended a courtesy extension to the complainant, having failed to respond by June the 8th and extended to June the 25th, which extension was ignored by the complainant. Subsequently, about a month later, by correspondence from the Maine Human Rights Commission, dated July 21st, 2020, the commission extended the deadline to August the 11th and represented that, failing which, I will dismiss your case for failure to cooperate. And they confirmed that a postmark would not be good enough. The submission had to be received by August the 11th. It appears that this deadline was ignored by the complainant and by the Maine Human Rights Commission. It is difficult to explain to a respondent who has participated in this process in good faith how any of the foregoing rises to the level of due process or fair treatment to the respondent. Evidently, the complainant was allowed a phone interview on September 1st, 2020, roughly 3 weeks after the promised dismissal of the matter. Again, we did receive I'll call it a JPEG. Technically, it may not be the correct terminology, but we were able to review that record. And again, the complainant was both foul-mouthed and irrational, but there is no mention of this in the investigator's report, despite the fact that that conduct of the complainant is consistent with what the respondent complained of and is represented in the David Blaze affidavit. There is a
Sir,
conclusory.
please don't use the names of any third parties.
I apologize. There is a conclusory statement in the investigator's report that the complainant is disabled and that he has a service dog. Again, the respondent has not received one iota of evidence that either of those statements is true, despite having complied with the requirement of a non-disclosure agreement. There is no mention in the investigator's report of the complainant's misleading conduct at the time of both visits, concealing the presence of a dog, despite the fact that there is a no pet policy at the motel. There is no mention by the investigator of the complainant's conduct disturbing other guests. If the complainant's disturbing, loud, racist, and foul-mouthed conduct is, I'm asking that as a question, is the complainant's disturbing, loud, racist, and foul-mouthed conduct irrelevant to this inquiry? The Human Rights Commission may say yes, because in this case, at counsel's instruction, the respondent was forthright in disclosing that it had required proof that the service dog was in fact a service dog. I would submit, and I would ask the commission to consider as an issue of fairness, in light of the conduct of the complainant and in light of the comparatively benign conduct of the respondent, running afoul of the statute, asking for proof that the dog was a service dog, but in the context of a customer, a guest who had twice hidden the fact of a service dog, and when asked, do you have any proof that this is a service dog, had declined to do so. And in both cases, the first case, frankly, was a one-night stay. They found out the morning he was leaving that he had a dog. The second case, it was on his second day of his stay that they found out he had a dog, and he was permitted to stay for the balance of the 6 days. It was technically a violation of statute, but it was completely benign. They had frankly given him a $50 discount on his, I'm going to strike that because I don't think we had that in any of the papers, so that's not relevant. But they had not been unkind or uncooperative with the guest. He was permitted to stay for the full length of his stay on both occasions. The sum total of the experience, of this experience, was a failure of fair and impartial process. We still don't have any evidence that this dog is anything other than a pet, other than a conclusory statement. Our recommendation in our request is that this case should be dismissed based upon the complainant's failure to respond on June 8th, on June 25th, and most dramatically on August 11th, when he was assured that were the response not received by that day, his case would be dismissed for failure to cooperate. Fairness and due process is a two-way street. The respondent has done everything they can to comply with the requirements of this commission. This matter should have been dismissed on August the 11th, and that's what we request. I reserve the balance of my time.
Thank you, Mr. Doyle. Commissioners, any commissioner who has a question for Mr. Doyle, raise your hand and I'll call on you. First, Commissioner Ashby, then Commissioner David.
Yes, thank you. So you're kind of up against the prohibition against asking for specific proof of the need for the animal. or proof of, I'm sorry, let me rephrase that, certification or other type of proof in that respect. But in this case, do you know what it is that your client asked of the complainant for, quote, proof, unquote?
I know that they said, can you provide any proof that the dog is a service animal? I know they should not have asked that. However, they have received, they've had, as you saw in our papers, they don't keep records on how many service dogs have stayed there. But when I asked them to estimate, they said it was more than 10, but probably less than 25. In most of those cases, people have cards that show the dog is a service animal, and they provide a copy, or they don't, they show them the card, and they accept that, and the guest goes into the room. And it just, I don't know if it's part of your question, but it did come up in our inquiry. They don't charge a guest additional money for having a pet or for having a service dog. They stay for the same price that they would if any other guest.
So just focusing on this question of mine, though, you agree that that your client can make some inquiry of a person who claims they have a service animal, right?
Yes.
They may inquire, for example, what the nature of the service provided is. I'm paraphrasing, but you can make inquiries. Do you need the animal, and what services does the animal provide? You can't require performance, right? You can't require a performance of those tasks, but you can make that kind of inquiry, correct?
That is correct.
Well, would your case would you be well advised to argue that it's an expansive reading of the word proof, requesting proof, to say that you're requesting of the person to explain what you're permissibly allowed to ask the person to explain? I mean, if the record reflected that your client asked for certification, a piece of paper, that may be different than if there was a general inquiry about, hey, explain to me how your dog is a service animal.
Yeah, I don't know the specific nature of the request. I do know that my client said they asked for some proof that the dog was a service animal, and they never received any proof that the dog was a service animal.
Okay, thank you.
Thank you.
Mr. David?
Isn't that the end of the case then, if they say that they asked for proof and never received it, that they're not allowed to ask for proof?
I don't believe that should be the end of the case, Mr. Davis. I think that all of the other evidence is relevant. And I think the linchpin of this case, the keystone, is the Maine Human Rights Commission itself saying, you must respond by August the 11th, which was the second extended deadline, third deadline on the same piece. You must respond by that date. It can't be a postmark. It must be received, or this case will be dismissed.
Okay, well,
I beg pardon?
I hear that procedural argument. I don't know what to do with that. I don't think I've ever been asked to review that. I mean, the commission does that and council does that. But you agree that he told them that it was a service animal when they said, hey, there's no pets allowed. The investigator says that okay.
That's correct.
Thank you.
Thank you.
Any other commissioner questions for Mr. Doyle at this point? Seeing none, Mr. Doyle, when we come back to you, you'll have about 45 seconds left. I'm going to mute you for now. And then we're going to turn to Attorney Hoffman. You are currently muted.
Can you hear me now, Executive Director Sneerson? Perfect.
I can, yes.
Good morning, Executive Director Sneerson, Counsel for the Commission, Ms. Attorney Hirsch, and Commissioners. My name is Attorney Kelly Hoffman. I am a partner at Norman Hansen and Detroit in Portland, and I represent the complainant, Mr. Caterino, in this matter. As the investigator will tell you when she summarizes her report in this matter, a service law in Maine and in federal law generally relating to public accommodations is that there are two inquiries that can be asked. One is whether an animal qualifies as a service animal because of Mr. Caterino's disability. He has cognitive functioning problems from a traumatic brain injury, and he has seizures. The dog signals when he is about to have a seizure, and this is common for dogs to be trained for this type of traumatic brain injury related to whether it's a car accident or some type of military training. I've had several cases in that. And what work the dog or the animal has been trained to perform. So I've already summarized what they are here. He had a traumatic brain injury. He had a note from the doctor. He gave the note to them. And he said that the dog performs, it puts up its paw and lets him know when he is about to have a seizure so that he can, in worst case scenario, or what we would all think of, take the scissors out of his hand and put them down. Put the hot tea or the hot coffee during the winter months of Maine down instead of spilling it on each other. This is what the dog does. Now, I respect and I understand because I litigate both sides of this issue. I understand that some patrons apparently are providing cards. What you should know for the commission, and I think that this is a problem at a federal and a state level, is that there is no way that you can receive a so-called certification for a service dog anywhere in this country. If you did a simple Google search, you would see that lots of people are paid $30,000, $40,000, $50,000 for a trained dog to stop seizures, to help individuals with various types of issues that they have. And yet those dogs, those monkeys, those service animals cannot be certified in any federal agency. So I don't know what these cards are that patrons are providing. It very well could be a card that you and I give to the individual. You can register any one of your animals as a service animal by going onto a simple website and seeing that. I respect the concern about asking what type of, whether this is a service animal. However, in this case, this motel and its representatives didn't simply ask that. They, if you read the papers that have been submitted, and what opposing counsel has basically said was they were concerned because the dog didn't have a service vest. The dog does not need to have a service vest. I could slap a service vest on my dog. That doesn't make it a service animal. And they do not need to provide proof of the disability or proof of the service animal. Now, it's my belief that opposing counsel opened the door to say that he's asked his people how many times that they've had service animals at the motel. He said to you just moments ago that it was more than 10, but less than 20. If you did a simple Google search of this motel, you would see the reviews are riddled with the fact that this motel frequently turns away individuals that have service animals.
Attorney Hoffman, I'm going to ask that you not include things that are not in the record. I should have done that with Mr. Doyle and did not because he kept it a little vague.
I understand. Thank you, Executive Director Sneerson. Thank you. Go ahead. Sorry, my child just walked in the room. As well, importantly, I hope that each of you have been able to see, prior to my entry of appearance in this case, Mr. Caterino was incapable of getting video off of his phone. I don't think I'm necessarily showing my age, but I do understand that it can a lot of times be incredibly difficult to take things off of phones and computers in order to produce them throughout the process. We have provided a video. I don't know, based upon where we are in the process, whether the individual who submitted an affidavit who said that my client was belligerent was the man that was in that video. However, it seems like everybody was pretty heated. The simple fact that my client was upset and that he cursed and that the motel patrons cursed and made various signs with their hands that were incredibly offensive has no basis in an inquiry here. If you could skirt the Maine Human Rights Act and the federal laws around public accommodations by saying that a complainant became upset and that the respondents became upset simply because we were talking about discrimination laws. That would be laughable. Also, we're in a global pandemic. So while I understand again that the complainant apparently was given a number of extensions prior to my entry of appearance, that is commonplace in the commission as it is in federal and state court, because we're in a global pandemic and we have been for almost 2 years. In sum, I would say that, again, the inquiry under the law is simple. There's no way to run around that. Whether an animal qualifies as a service animal and for purposes of a public accommodations, you're required to ask, you are allowed to ask only 2 questions, whether it's because of a disability and what work or task the animal has been trained to perform. I disagree that going beyond that is acceptable under the law. If it was, and if we were required to provide a letter, a service vest, a number of other things, I think that the inquiry is a slippery slope. It is there to protect individuals who have disabilities, and he is one of those people. Finally, I would add that while he was ultimately allowed to stay at the hotel, he was not allowed to stay there moving forward. And that to me is problematic. The simple fact that he was asked to leave and then ultimately allowed to come back because the owner's son intervened is problematic. This isn't a benign violation of the law. If it was, I wouldn't be sitting here arguing in front of all of you. Thank you.
Thank you, Attorney Hoffman. You'll have about 3.5 minutes left, but first I'm going to ask commissioners, if you have any questions for Attorney Hoffman, raise your hand, commissioners, and I will call on you. I do not. Commissioner David?
Attorney Hoffman, do I understand you to say that you did provide a letter indicating his disability?
I believe that that is true, and he said that in his paperwork. He also said it in the video that we submitted, which had he repeatedly references and says, I gave her a doctor's note to show that I was disabled. So he's saying that on video. There is a man, I don't know.
Who's the her? The investigator?
No, I believe that the owners are a man, a husband and a wife. It's my understanding of that. Opposing counsel could speak to that.
And opposing counsel says that he's never had any indication, any written documentation of the disability, even though he signed a non-disclosure agreement. I assume that that's a requirement to be able to then demand that.
And I have no problem providing that. This is the first that I'm hearing of that, is right here, right now. I don't have any problem providing something about him being disabled. To answer your question, sir, more directly, that is, again, a disingenuous argument, because if you look at their filings on April 13th, 2020, they casually and sort of cavalierly and almost in an obnoxious way, right? We're not sure if he's disabled. I actually put this in quotes for my argument today, but he did present himself in a, quote, unwell fashion. So we suspected there may be some issue. So while they're saying they don't think he's disabled, they also take pot shots at him for possibly being disabled. So I'm happy to provide that. I'm representing to you as an officer of the law that this man is disabled. He had a traumatic brain injury. It's obvious that he had, and it's obvious that he has a seizure dog. That's why I'm here with you, respectfully.
Okay, thank you. Yeah, I mean, I can see that I'm falling into the trap of demanding proof when that's not an element of the law. Thank you.
Any other commissioner questions for Attorney Hoffman? Seeing none. All right. At this point, we'll turn back to Mr. Doyle. Mr. Doyle, you have about 45 seconds left. If you want to use them, you don't have to, but you are currently muted. There you go.
I would speak only to a couple of issues. I reviewed the record. There's still nothing in the record that we've received that would reflect that Mr. Caterino has a disability or that the dog in question was a service dog. So I would request that to be stricken from the record, as there is nothing in the record that would confirm that. In addition, it is not necessarily germane, but to characterize pleadings in the case as potshots when we were trying to be clear and respectful, and not to disregard elements that we gave an indication that there could be a problem. To
Mr.
characterize
Doyle.
those as potshots is
Mis-
disrespectful.
Mr.
and
Doyle,
that has to be stricken.
that's your time.
Thank you.
Any follow-up questions from commissioners for Mr. Doyle? Seeing none, I'm going to mute you, Mr. Doyle. Attorney Hoffman, you have about 3.5 minutes left, if you care to use them.
With respect, Executive Director Sneerson, Council, Attorney Hirsch, and Commissioners, if you have questions, I'm happy to answer them. Otherwise, yeah, I'm finalized with my oral argument this morning.
Thank you. Any follow-up questions for Attorney Hoffman from commissioners? Seeing none. Thank you, Attorney Hoffman. And then we would turn to the investigator, Ms. Brindley.
Good morning, everyone. My name is Alex Brindley. I was the investigator assigned to this case. Now, I want to briefly address the questions regarding procedure. Now, the questions that were asked occurred before I was assigned. However, it is my understanding that, generally we do provide extensions occasionally to, to get the responses. And in this case, a reasonable accommodation was actually provided to the complainant, so that he was able to provide his rebuttal to the respondent's answer in video form or audio form. So those are the audio recordings that the respondent attorney has referenced in this matter. Other than that, I don't think I have anything else to add at this time, but I'm open to any questions.
Thank you. Any commissioner questions for the investigator? Seeing, Commissioner O'Brien.
Thank you. I think you just touched on this, but as a fairly new commissioner, I was wondering about that issue. Are there consequences when submissions are beyond the deadline? Do they?
Yeah, I'll field that one. It's a procedural issue.
Okay.
And Alex is right. In this case, it's routinely in the beginning of the case, the early pleading stage, we give respondent a certain amount of time to answer the complaint and commission questions. And if they don't, we routinely give an extension in every case, just as we do when we turn, if we get the respondent's answers, we turn and send them to the complainant. And if we don't receive them, we routinely give the complainant an extension of time. In this case, this was as the pandemic was beginning, and the complainant did request an additional extension as a reasonable accommodation for the exact disability that's at issue in this case, which we granted. It is also common that if I send out lots and lots of letters telling people if they don't get me a document or they don't respond by a certain date, I will dismiss the case. And then I don't even get to it for months at a time because there's too much paper. But if in the meantime, we have received a substantive response, the commission would always rather resolve a case on the merits rather than as a default when we have actual evidence to look at. And so that's what happened in this case. I think I saw you say, Commissioner O'Brien, I think you were set. I just wanted to check.
I said, thank you, all set.
Okay, yeah. Any other commissioner questions for the investigator? Seeing none. Thank you, Alex.
Thank you.
Commissioners, there's one recommended decision, so we would be looking for a motion at this time.
I'll move that there are reasonable grounds to believe that the respondent discriminated against the complainant on the basis of disability by making the unlawful inquiry, and that the conciliation be attempted in accordance with the act.
Second.
So a motion to find reasonable grounds has been moved and seconded. Is there any discussion among commissioners?
So I'm sympathetic to a business owner who is faced with a problem like this. And the state of the law is very challenging. It's a pretty sophisticated, it's limited, but it's pretty sophisticated inquiry or a narrow inquiry that we permit in these cases. And when it would be instinctive, I would think, for a business owner when approached with this problem to ask for proof. And I tried to give the counsel for the respondent a lifeline by maybe looking close at the actual inquiry that was made to determine whether or not a request for so-called proof could mean a request to explain that the animal is required for a disability and what the animal does in service of the complainant. Because I'm not sure that people know instinctively to ask specifically those questions. The record is a little light as to specifically what so-called proof was required, but I got a concession, I guess, from the respondent's counsel that there was actual proof requested and none provided. In the future, I think it'd be helpful to know specifically what questions are asked, because I don't know that we can require in our analyses that respondents in situations like this use the magic words. But you are, as the current state of the law is, if you are asking for so-called proof and everyone has in their mind written documentation, that is a violation of the law. It's pretty clear. It's not a close call in this case. It's just a challenging, the law is challenging in this case. I'm sympathetic to business owners in this problem, facing this problem, but I don't think we have any choice but to rule in favor of my motion.
Any other discussion among commissioners of the pending motion? Commissioner Doosan, and then Commissioner David.
Yes, I'm inspired by my fellow commissioners' comments to just provide for this discussion that I think the law is very much on point. I think that respondent's counsel, even in his presentation, has repeatedly confirmed not only demand for proof of that the animal in question was a service animal, but pretty closely has confirmed that there would have indeed been a demand for proof of disability and nature of disability. And a person with a disability should not be required to disclose their all of that personal information in order to have the services of a service animal and in order to be able to enjoy public accommodations. So I think that the ruling on this is pretty clear, and I thank the investigator for a thorough job. I thank both counsel for a thorough presentation of the arguments.
Commissioner David, did you have comments?
Yes, I totally agree on the substance. I didn't want to ignore Attorney Doyle. He began by addressing the commission and asking the commissioners to make the procedural ruling on the time frame, and I certainly am not going to do that, and I don't see that any other commissioner is going to do that. We're supporting our staff in terms of their discretion about procedural requirements and extensions. So I'm not ignoring it, but I'm rejecting it.
Any other discussion among commissioners? Seeing none. So the motion is to find reasonable grounds to believe that the Northeastern Motel discriminated against Mr. Caterino on the basis of disability. If you say yes, you are agreeing with that motion. Commissioner Whitworth.
Yes.
Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner Doosan.
Yes.
Commissioner O'Brien.
Yes.
So the finding is reasonable grounds, and the commission will send a letter and an email to both parties and counsel after the meeting, inviting them to conciliation. And thank you for being here and for agreeing to take the case out of order. At this point,
Thank you.
we will thank you. At this point, we will be moving on to, we'll go back, I guess, to the order that we were in, Commissioner Whitworth. So that would put us calling the Shuck case.
So sorry. The next case, PA 20-0008A-F, Lauren Shuck v. eBay Inc. et al. This is a no reasonable grounds recommendation. Is there anybody here for the complainant?
I have not seen anyone on the call. I don't believe Mr. Shuck is here. And typically, the process the commission has followed when the party who would object is not present is to make a motion to adopt the recommended findings of the investigator without further discussion or hearing.
Given that, then I will move to adopt the recommendation of the investigator, that there are no reasonable grounds to believe that eBay et al. Discriminated against Lauren Shuck on the basis of his disability or retaliated against him for engaging in MHRA protected activity, and the complaint should be dismissed in accordance with the act.
Second.
Okay, thank you. So the motion is to find no reasonable grounds and it's been seconded. Is there any discussion among commissioners? Seeing none. So the motion is for no reasonable grounds. If you say yes, you are in agreement with that finding. Commissioner Whitworth?
Yes.
Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner Dusan?
Yes.
Commissioner O'Brien?
Yes.
Okay, thank you. So the finding is no reasonable grounds, and the commission will send the parties a letter. And that is the end of that one.
Our
I believe
next
we will have
case-
several similar hearings for the next few cases.
Okay, so the next case, E20-0022, George Stanley v. RC Management, as a no reasonable grounds recommendation. Is there anybody here for the complainant?
I do not see Mr. Stanley on the call in any fashion. And so again, typically we would, when the complainant who's opposing the recommended finding is not present, typically we would have a motion to adopt the recommended finding.
I'll move to adopt the recommended findings that there's no reasonable grounds to believe there was.
Oh, you muted yourself, Ed.
Second.
Hold on, hold
Yeah.
on. You were, Ed, could you repeat your motion just so I'm clear?
Yes. Yes, I'm sorry. I keep moving my screen around. Yes, I'm moving that we find that there's no reasonable grounds to believe that respondent discriminated against complainant, and that there's no reasonable grounds to find that respondent discriminated on the basis of race, ancestry, physical or mental disability. Oh, I'm sorry. The first one is no reasonable grounds to believe there was retaliation. That usually comes second, and that the complaint should be dismissed. So I'm moving that no reasonable grounds on both of them together.
And Jill, did you second that?
Yes, I did. Thank you.
Okay, thank you. So the motion is to find no reasonable grounds on both claims. It's been seconded. Is there any discussion among commissioners? Seeing none. If you vote yes, you're in agreement with no reasonable grounds finding on both claims. Commissioner Whitworth?
Yes.
Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner Dusan?
Yes.
Commissioner O'Brien?
Yes.
Okay, the finding is no reasonable grounds on both claims, and the commission will send the parties and attorneys a letter.
Okay, and our next case then, E/PA20-0023, Kevin Payne v. Harrison Food Bank as a no reasonable grounds recommendation. Is there anybody here for the complainant?
I do not see the complainant on this call in any fashion. So if you're an attorney representing him, let us know. I do not believe Mr. Payne is present. So again, typically our process would be to adopt the recommended findings, which are in this case 3 no reasonable grounds claims.
I will move to adopt the recommendations of the investigator that there are no reasonable grounds to believe that Harrison Food Bank discriminated against Kevin Payne on the basis of disability in public accommodation and/or employment. Additionally, that they retaliated against Kevin Payne for engaging in MHRA protected activity in public accommodations and employment, and that there are no reasonable grounds to believe that Harrison Food Bank retaliated against Kevin Payne for engaging in WPA protected activity in employment, and the complaints should be dismissed in accordance with the act.
Second.
So it's been moved to find no reasonable grounds on all claims and seconded. Is there any discussion among commissioners? Seeing none. The motion is to find no reasonable grounds on all claims. If you say yes, you are agreeing with that. Commissioner Whitworth.
Yes.
Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner Doosan.
Yes.
Commissioner O'Brien.
Yes.
So the findings are no reasonable grounds, and the commission will send the parties a letter. And I believe the next case people are here for.
So the next case, E20-0092, James A. Truziani v. Crooker Construction. As a no reasonable grounds recommendation, is there anybody here for the complainant?
Yes. Yes, can you hear me?
We can, yes. So Mr. Truziani, you have 10 minutes, okay?
And thank you very much. Thank you, commissioners, members of the board. Briefly, this is all about several events. I complained about smoking on January 10th to my supervisor. I complained about some conditions on January 16th, 17th, and I wrote a letter dated the 20th. And we had a meeting on the 21st with the HR director, Jill Rivas, and the general superintendent.
Mr. Truziani, no names, please. We've given them, thank you.
I'm sorry. HR director and the general superintendent. We discussed all those things. In the fact finding, a lot of the things were not, that we discussed are not being mentioned. I brought up legal things. I brought up safety things, health issues, and some possible legal matters with the company was doing, in my opinion. After the meeting lasted about an hour, we agreed to meet on the 24th. Again, with the two people, the HR director and general superintendent. The meetings were conducted in her office. For the record, there was no note taken or tape recording of the meetings. So this is all hearsay information on both sides. The first thing that came out of that meeting was they told me right up front, they did not look into 85 to 90% of the things I brought forward, because the general superintendent said if he did not physically see any of these things going on or know about firsthand, he would not look into. I asked him, how is that me getting a fair hearing when I bring these up? After that, the HR director stated that she agreed with the general superintendent on the things that they did look into, that they didn't think it was as severe as I thought they were. But at this time on the 24th, instead of telling me that I should just go back to work and we'll work through this, they said, but we will accept your resignation at this time. That's not me refusing to go back to work. That's them trying to get me to resign because they don't want to look into the actual complaints that I brought forward. After that, there was a discussion about what was to be done next. I said, well, now that you mentioned that you don't want me back, it's time to discuss me leaving the company after 26 years. They want me gone. So there was discussion about a possible settlement. I didn't bring it up. I asked both of them if they had the right to discuss, negotiate, and make a settlement with me at that time. They both said no. At that time, I said, well, we need to get somebody in here that can discuss where we're going next. I personally was starting to lead the meeting. At that time, the HR director stated, but she said, I have the right to ask you what you'd be looking for. In your notes, there was mention of money and stuff. That was what was discussed. That wasn't me extorting money from the company. But what's really missing in this finding of facts is the phone call that took place on the 29th between the HR director and myself at 2:29 p.m. It lasted 4 minutes and 45 seconds. I called her back on Crook's telephone number and her extension. And that's when she notified me that my employment at Crook's Construction is terminated by what she called administrative separation. I asked her, what terms of administrative separation are you using? And she says, I'm terminating you because we can't confirm or deny any of your claims that you brought forward. So on the 24th, they're saying that they don't exist, they're not too severe. But on the 29th, she's saying, I am now fired because I can't confirm and deny any of my claims. Then the following day, she wrote me a letter, which you all should have. It stated, this letter is confirming administrative separation from Crooked Construction. In that letter, it doesn't say what legal term administrative separation is she using. She doesn't state in here that it's because I refuse to go back to work. The next paragraph, she talks about the weather conditions and the smoking conditions she brought up. And she said that she fixed the smoking conditions that I was concerned with by saying that they have the right to be smoking on or around equipment out back, not on the federal law under my Part 46 rights, under my mining rights. So my only concern and my disagreement is I never was asked to go back to work. And I never refused to go back to work. I was asked to put my resignation in on the 24th at a meeting because they won't look up or look into most of any of my concerns. And then I get fired on the telephone after 26 years. That's a nice way to fire somebody. Based on they can't confirm or deny any of my claims. Okay, there's also due process of law. I asked for in a letter that you should have on the 27th, that I asked for mediation because I don't agree with any of the things that they up to the 27th, and they denied that. So I'm saying I was let go for the wrong reasons. I did not refuse to go back to work. I didn't try to extort no money from the company. She asked me what I was looking for, even though she didn't have the right to ask me. That's all I really got. I'm not going to get into what he says, she says at the meetings. That's the gist of the article of the case. I brought up serious possible violations on health, safety, work-related federal laws, and they refuse to even look at them. And I get fired because they can't confirm or deny any of my claims. And that was discussed with Mr. Bob Boucher when we had our hearing. We discussed that because I even asked him, if you're going to rule, what legal grounds of legal administrative separation did they use to let me go? And why was I didn't? Because he even asked me, how come I didn't try to bring somebody else in? I did in the letter, and I was refused. So my case is based on they let me go because they wanted me out because I know too much about some of the things that I brought up is true. So that's my case. I didn't refuse to go back to work. I was never asked to go back to work. And I was let go on a phone conversation because she can't confirm or deny any of my claims. Thank you. That's all I have.
Thank you, Mr. Truciani. When we come back to you, you'll have about 3 minutes, but first I'm going to see if our commissioners have any questions for you. Any commissioners, if you have questions for Mr. Truciani, raise your hand and I will call on you. And we do not currently have any hands raised by our 5 commissioners. So just so you know, Mr. Truciani, we'll get back to you with 3 minutes after we hear from Crooker Construction, okay? So just stay on the line. And then we would turn to Crooker, and I think that's you, Mr. Frame.
Yes, can you hear me okay, Ms. Nearson?
I can, yep.
Great. Good morning. My name is Greg Frame and I represent Crooker Construction here. As part of this, I urge you to uphold Investigator Bouchain's reasoned and thoughtful recommended finding of no reasonable grounds. The claim here is that Crooker Construction violated the Human Rights Act, engaged in and violated it because Mr. Truciani was a whistleblower. Mr. Truciani, or complainant, was most recently hired in 2017. While he was frequently absent, he never asked for accommodations nor disclose any disability. Crooker was very lenient in giving him time off. Over time, Crooker continued to work with Mr. Truciani. At Crooker, safety is a top priority. They have weekly and sometimes daily meetings on safety and open door policy where anyone can feel free to discuss any issue. Crooker acknowledges that Mr. Truciani made 2 complaints. The first was a complaint about smoking. The second was a complaint about weather. The first complaint came in on around January 11th, and it was about smoking near a crusher. Crooker, in response to the concerns, the operations manager spoke with 6 employees who could have been involved and reiterated the company smoking policy to them. The crushing foreperson was also asked to, and did in fact, speak with all employees and reiterate the no smoking policy. So this was immediate, prompt remedial measures based upon a concern raised by Mr. Truciani. On January 16th, Mr. Truciani complained about working in cold weather. This is work that's done outside. Crooker has a policy that when the weather is too cold, they will cease operations and work inside. The weather this day was not colder than normal. Temperatures at this time, in fact, were fairly mild. This is confirmed via weather data and objectively outlined in Mr. Bouchain's report. Complainant at that time walked off the job site and didn't return. The HR director began investigating this complaint as well, and then began kind of a series of communications between Mr. Truciani and HR and the company while they were in the midst of investigating. He, on January 21st, threatened that he was going to, quote, go to the press about this. He further, and the contemporaneous notes are pretty clear. He threatened to demanded a settlement so he could go into early retirement. He quite simply refused to come back to work. There's no debate about that. Consistent with the company policy, this was considered a voluntary quit, despite him saying, I want X amount of dollars and I'm not coming back to work, and I don't want an apology. I want an early retirement. Crooker continued to keep him employed until finally it was clear that he was not coming back to work, which is pretty amazing that they did so. It's important to note here that typically the complainant's prima facie burden is an easy one. They engage in protected conduct, subjected to adverse employment action, and there's some sort of causal connection. Here, the investigator noted that there's certainly an open question as to whether the complaints were in fact made in good faith. But assuming that those complaints were, that the prima facie burden has been met. Investigator Beauchesne noted that the complainant's own words about file, suit, and alert the press and demanding outrageous things to come back to work raised the question as to whether he was really concerned about safety or about money. Investigator Beauchesne also appropriately noted that the complainant wasn't disciplined at the time for refusing to work on a day that he clearly had lied about the weather, and that can be objectively demonstrated. This is how an employer is supposed to handle employee complaints. When the complaint was made, Crooker met with the complainant to discuss his concerns, met with a number of employees, took action. But complainant made clear that he didn't want an apology, and one wasn't coming, by the way, but only wanted an early retirement package or to sue Crooker, and here we are. The complaints, prior to January 11th, Mr. Truciani never reported any concerns. Again, this is a company that has frequent safety meetings where employees participate in those meetings, where employees are frequently providing best practices on safety. And there's an open door to the HR, to the superintendent, and to the owner. Complainant never availed themselves of these opportunities until late, and then took a pretty strident approach. And Crooker at some point had no choice but to, when he refused to come to work, to consider this a voluntary quit. Crooker engaged in the interactive process, which is what we want, to address issues and have corrective concerns, and even invited the employee back once they were certain that the concerns were invalid, but that they had addressed them. So if there are any questions, I'm happy to take them, but I certainly urge you to uphold Investigator Beauchesne's recommendation of no reasonable grounds to believe that discrimination has occurred here.
Thank you, Mr. Frame. If any commissioners have questions for Mr. Frame, raise your hand and I will get to you. I do not see any hands raised from commissioners. Mr. Truciani, coming back to you. You have about 3 minutes left if you would like to use them, which you would have to unmute yourself first. There you go.
Hear me okay?
Yes, thank you.
First of all, if that's the way they conduct business, why did they ask me to resign? Why did they want to accept my resignation on 24th? And then why did on the 29th, when we had the phone conversation, when they said that I was done, she didn't say because I refused to go back to work. She was very clear on the phone that she stated the reason I'm letting you go by administrative separation was because we can't confirm or deny any of the allegations. And I don't know where they got their reports for the weather on the 16th. We also talked about the weather on the 17th when it was 11 degrees below zero. I also, in my package, said that there was I can prove the weather, but I'm not going to get into that. I did not extort money from them. I did not bring it up. They're the ones that brought it up when they told me that I was not coming back when they asked me to resign. At no time did they say, you can come back to work. We've done everything we can. Now it's up to me. Then that's a choice I could have made. But I was never given that choice. I was fired on the 29th on a phone conversation because they can't confirm or deny any of my claims. That's exactly what she said on the phone. And she lies in the paper when they say that they took care of the smoking policy. Because the federal guidelines on the Part 46 federal policy, there can't be no smoking in around any machine that's running that's under high pressure hydraulics or diesel. And they were still doing that after, quote, they took care of it. So I did not refuse to go back to work. I was let go by a phone conversation on the 29th, 2:29 p.m. on Crooker's phone conversation because they can't confirm or deny any of my claims. Thank you.
Thank you, Mr. Truciani. Any commissioners have follow-up questions for Mr. Truciani? If so, raise your hand and I will get to you. I do not see any commissioners' hands raised. So at this time, I will turn back to Mr. Frame Mr. Frame, you have about 3.5 minutes left.
Thank you, Ms. Neerson. I guess I would only invite the commissioners. I'm sure they've already, they have reviewed everything, but Exhibit Q is the letter following up on the phone conversation of January 29th. Mr. Truciani says that they weren't able to confirm or deny any of his claims. That letter is as crystal clear as it can be. It talks about the smoking concerns, the investigation, how there was no violation of policy, but how they reinforced the policy. It talked about the weather concerns, how they met with other employees, and no employees were able to. I reported to you that other employees were working in the same conditions that they did not feel was unreasonably working outside. I mean, this is what was said at that meeting. This was the reason. And then it says, you know, while I shared the results of our investigation, our proposed remedial action, you stated that our response was not acceptable and returning was not an option to you. That's a voluntary quit. That's an administrative separation. So I think the record, the book matches the movie here. The record is crystal clear. Thank you.
Thank you, Mr. Frame. Commissioners, any follow-up questions for Mr. Frame? Seeing none. Thank you to both of the parties, and then we would turn to the investigator, to Mr. Beauchesne.
Morning, commissioners. Just to cover a few points that have already been highlighted about this particular case. Excuse me, as commissioners are aware, the complainant alleged he was involuntarily separated from employment for complaining about what he believed to be illegal and/or unsafe activity and workplace conditions, including being compelled to work in extremely cold temperatures on 2 specific dates in January of that year. The respondent is a company that performs primarily outdoor work, and it is undisputed that they did have a company policy that dictated that if outside weather was 0 Fahrenheit or lower, that the crew worked inside performing trainings or other types of activity versus working outside. On January 20th, complainant left a letter on the HR director's desk regarding a number of weather-related safety concerns, specifically those on January 16th and 17th, in addition to other alleged violations regarding the smoking policy, truck drivers using cell phones while working, as well as a claim that the company had covered up a failed drug test for a truck driver. That initial letter specifically included a statement that provided that he, quote, had an intent to file a hostile and harassment workplace environment claim in suit. HR met with complainant the very next day to get more information on these allegations. Notes from that meeting from HR reflect the complainant stated, quote, this is not about getting an apology. He was either going to sue or get early retirement. He also allegedly stated that he was not looking to come back, but that he didn't want to sue, but would if he has to. On January 4th, HR had another meeting with complainant wherein he was told that the allegations had been investigated, but could not be substantiated and that the company was accepting his resignation. Complainant has steadfastly disputed throughout the investigation that he ever offered his resignation, but rather instead only stated that he could not return until all of these safety concerns were addressed. At the conclusion of that meeting, complainant allegedly proposed a settlement with the company that included 2 years salary and health insurance, in addition to $40,000 in additional damages. In essence, this came down to initially whether or not complainant made his claims in good faith. That was called into question in this case in the fact that he had threatened suit in his initial letter before respondent had even received his allegations and had any chance to investigate. Further, complainant's credibility was also called into question by his claims about the specific weather conditions on January 16th and 17th. It's rare in these types of cases that objective evidence can prove or disprove a particular claim. However, his claim that on January 16th that he was forced to work outside in freezing rain, snow, and sleet was belied by weather reports that indicated that on that particular day, there was a high of 33 to 34 degrees. He also alleged on January 17th that the temperature was 11 degrees below zero, including wind chill. Weather records in fact reflect that the weather that was 26 degrees, sunny, and with no wind. So in these particular situations, when called into a decision about who most likely is more credible with respect to what was discussed at that meetings, respondent was found to be more credible because complainant's claims about weather conditions were specifically disproven by weather records for that workplace on those days.
Thank you. Thank you, Bob. Commissioners, any questions for the investigator? I am not seeing any. Okay, so thanks, Bob. Commissioners, you've heard from the parties and from the investigator. There is one proposed finding, so we would be looking for a motion.
I move that we adopt the findings of the investigator. There are no reasonable grounds to believe respondent retaliated against complainant for engaging in WPA protected activity, and the complaint should be dismissed.
Second.
So there's a motion to find no reasonable grounds to believe that unlawful retaliation occurred. It's been seconded. Is there any discussion among commissioners? Seeing none. So the motion is to find no reasonable grounds. If you say yes, you are in agreement with that motion. Commissioner Whitworth.
Yes.
Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner Doosan.
Yes.
Commissioner O'Brien.
Yes.
So the finding is that there are no reasonable grounds to believe unlawful retaliation occurred, and the commission will send the parties and their attorneys a letter confirming that. Thank you for being here.
Okay, moving on to our next case, E20-0160, Grace Woodham v. LU 567. A no reasonable grounds recommendation. Is there anybody here for the complainant?
I have not seen anyone on the call, and the investigator is shaking their head as if to say they also do not see the complainant here. So again, as is typical, when the party who objects is not present, the commission would typically vote to adopt the recommended decision. So we would need a motion.
I'll make a motion. There are no reasonable grounds to believe that LU 567 discriminated against Grace Woodham on the basis of disability, sex, or sexual orientation, or retaliated against her for engaging in the MHRA protected activity.
Second.
So there's a motion to find no reasonable grounds, and it's been seconded. Is there any discussion among commissioners? Seeing none. So if the motion is to find no reasonable grounds on all claims, and if you say yes, you are agreeing with that. Commissioner Whitworth.
Yes.
Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner Doosan.
Yes.
Commissioner O'Brien.
Yes.
So the finding is no reasonable grounds, and the commission will send parties and council a letter to that effect.
Our next case, E20-0183, Philona Elliott v. O'Reilly Auto Parts, as a no reasonable grounds recommendation. Is there anybody here for the complainant?
Yes.
Hi, Ms. Elliott.
Yes.
Yep, so you have 10 minutes.
Okay, starting now?
Starting now.
Okay, well, first and foremost, thank you for hearing my case. I appreciate it. I feel like the commissioner's report, his findings, everything that led up to the layoff for O'Reilly's was, I felt, a key to why I got laid off. Again, my supervisor asked me to do other jobs that my male counterparts were not asked to do. We were all equals. We were all ISSs. I was asked to do returns. I was asked to do deliveries. And when I do deliveries, I would have to leave the store sometimes up to 2 to 3 to 4 hours a day to do deliveries. There's no way for me to be next to a phone to do my sales, according to O'Reilly's RIF thing, that why I was laid off. And there's no way to make that up. And when you're asked to do that 2, 3, 4 times a week, times that by a month, and my male counterparts are never asked to take a delivery, that I was told that they weren't allowed to leave the store. I mean, again, we were all equals, and I was asked to do other things. I was asked to work out front, which is not in my job description. It's not in their job description. Again, we all have the same job description, but yet I was asked to do these other things. My boss admitted during the investigation that, yes, he did ask me to do other things, and yes, he did not ask them to do other things. It was also his job to make sure my sales were, within what I was supposed to be doing. That was never discussed. That was also brought up. It was asked my boss, they did ask my boss several times if it was his job, and he said, yes, but as long as the sales in the store were doing well, he didn't do individual people. Well, again, if we were all equals, again, I feel like that because I was a female, it wasn't as important to him to make sure my sales were even with the other guy's sales. And again, the RIF was very vague. It was brought up that there was a problem with a customer, which I was never written up for. I mean, why that was brought up and allowed is beyond me, because it was never written up. There was a problem. We had discussed it. He even said what I did was right. So, again, that was brought up. And then my salary was brought up. Again, between the two guys that were there, I had 28 years of experience. The other guy only had 5, and the one that was just hired didn't even have 6 months to do. And again, I, being the female, was asked to train the new guy when my male counterpart, again, we have the same exact job title, and he was never asked to train him, And again, my sales would because of all this, of course, my sales suffered. I was asked to do so many different tasks that my other male counterparts weren't asked to do. There's no way for me, if my only job was like his, to sit there and answer the phone when it rang and not be away from the desk. I mean, I had to be away from my desk to do these other jobs. There was just no way for me to do them. And again, when your boss asks you to do something, that's what you do. I mean, I understand. I guess I get, maybe I should have been, hey, it's not my job description, but that's not how to be a team player. A team player is the one. And at the end of the day, my boss, at the end of the year or the end of the month, my boss should have had that discussion with me that, hey, Molly, your sales are lagging behind. This is where you need to be. And that was never, ever brought up. And my 2-year review was due March 30th. That review was never even done. My boss didn't even get that review done. And, in the findings, he even said there was no documentations of the complaints that were factored into this decision. And, if you factor everything that my boss asked me to do, and he admittedly asked me to do, and I had gone to my next supervisor and said, hey, listen, why is it that I'm only doing this? And he, again, they never did what they were supposed to do. My boss never wrote anything down. My boss never took documentations when we had meetings. And if you read O'Reilly's handbook, it says that's what he was supposed to do. And he never did any of that. And he didn't do what he was supposed to do. And therefore, yet my sales suffered, but I was never notified that my sales, it was part of what my job description was, that I had to meet a criteria for sales. And that was never brought up. And I just feel like that was so left out of the report. I feel like if you really look at everything that was asked of me to do and not my male counterparts, because I was female, I would have been, I mean, I was only $1,000 less than my male counterparts. And I was doing 5 other jobs, $1,000. And I'm doing 5 different jobs, including that job. I mean, again, my sales would have been way up there had I not been asked to do these 5 other jobs constantly. And I feel like that was part of the problem. And I get their riff, it was based on sales. And it said it was also based on my hourly rate, which should have never been based on that. They said it was on sales only. So why my hourly rate was brought up and why that the riff with a customer, a rude customer to me was brought up. I don't know why that had anything to do with the case. It was all about my boss asking me to do things that my male counterparts weren't asked to do. And I was the only female in the ISS position, and the other 2 were not asked to do that. And I was also asked to train the new guy who had very little knowledge of how to do, I mean, he had a lot of work experience working on cars, but he had no idea how to do customer service. And it takes a long time to train somebody. It takes a lot of effort and a lot of time away from what you need to do in order to do that. And my male counterpart was not asked to do that. And again, I think it was because I was female. And if you look at everything that was added up, it was, it just, I mean, you got to factor in everything that I was asked to do as a female that my male counterparts weren't asked to do. And we had the same job description. That's all I have to say. Thank you.
So you'll have about 3 minutes left when we come back to you, Ms. Elliott. But first, I'm going to see if any commissioners have any questions for you. Commissioners, if you have questions for Ms. Elliott, yep, I see one. Raise your hand and I will get to you. So first Commissioner Ashby and then Commissioner David.
Thank you. Hi, Ms. Elliott.
Hello.
So the investigator made a finding that when you were let go, another male employee from the same store was let go. First of all, is that your recollection as well?
Yes, but he did have a different job description.
Right. Were there any female employees in the store left behind remaining in employment?
In different job positions, yes. Every employee at O'Reilly's has a job position.
So there were other females working in your store?
Correct.
Thank you. No further questions.
Commissioner David?
Yes, good morning, Ms. Elliott.
Good morning.
You were hired in March of 2018. Were there any performance reviews of your employment before this happened in the summer of 2020?
Yes, I did have a 1-year review. It was an excellent review. My boss did say that he doesn't give anybody 4s on a perfect review because that's not who he is, but he did give me a perfect 4 on my job performance, that I go above and beyond what's asked of me. And it was a very, very good review.
And did I understand you to say that you were let go and a person that had only been there 6 months was retained? Do you know
Correct.
Correct?
Yes.
And do you know what that person's, you'd been there 2 years, although you emphasize your 28 years experience.
Mm-hmm.
Do you know what his prior experience was? Is that in the record?
Yeah, he owned a garage. He worked on vehicles. He had no experience he was great at putting parts in and working on vehicles, but he had no customer service, no computer skills, that type of.
And my last question, the thing that bothered me most when I read this was this business about a score on a culture exam. Do you know what that is? And,
No.
and is the exam or the questions in the record?
No.
I'll ask that of the attorney too. You don't
Yeah.
know
No.
what it is?
No.
Okay.
It said, they told me it was all based on sales, and my sales were $1,000 less than my male employee, my 2 other male employees.
Well, that's not what they told the commission. Thank you.
What did they? Oh, What did they tell the commission?
That it was based on the score of this evaluation for who would be selected for the RIF.
They told me it was based on sales.
Any other commissioner questions for Ms. Elliott at this time? Seeing none. All right, Ms. Elliott, you'll have about 3 minutes left after we hear from the respondent. I'm going to mute you for now, okay?
Thank you.
Yep. Mr. Tainter, I believe.
Yes, thank you, Executive Director Sneerson. Can the commission hear me okay?
Yes.
Great. So my name is Chris Tainter. I represent O'Reilly Auto Parts. What I want to do first is just address a few things that Ms. Elliott said that I think are not properly part of the record, and I just want to clarify what is and is not appropriate for consideration. I think she made a statement that she was told that her male counterparts were not allowed to leave the store. I don't believe that is anything that has been included in any of the filings in the case, and I don't think it's part of the record. She mentioned that she was asked to work out front, and I take it what she means that she was occasionally asked to work at the retail counter. And again, I don't think that's part of the record. I don't believe that was part of her complaint or anything that was discussed in the fact-find conference. And just so that the commission understands, because it may not be obvious, I'm not sure how much this was explained in the papers. O'Reilly has sort of two parts of its business. It has a retail store where you or I could walk in and buy auto parts from someone standing at the counter. And it also has what they call the installer service part of the business. And that's what Ms. Elliott was. She was an installer service specialist. And so she typically worked with garages and car dealerships and that sort of thing, professional customers. And so she made a comment here that she worked out front, meaning in the retail side of the business. And I don't believe that's part of the record. She also made a comment that the store manager, Eric Remick, had
no names.
I'm sorry, I apologize. She also asserted that her direct supervisor, the manager of the store, admitted that he had her do things that her male counterparts were not required to do. And I think that's an inaccurate statement. And we can talk about that more in a minute. And she also made the statement that there was $1,000 difference in sales between her and her male counterparts. Again, I don't think that's accurate or part of the record. What I will say about Ms. Elliott's objection to the investigative report is that she primarily takes issue with the investigator's ultimate conclusion and not with the facts that underlie that conclusion. She says, and I just read her objection again a moment ago, at least 4 different times, that she was the victim of discrimination, that she was treated differently because she was a woman. That's not, at least as I construe this, a disagreement with factual findings. It's a disagreement with the ultimate conclusion made on the basis of the facts. At page 4 of the investigator's report, the statement appears that nothing in the record establishes that the complainant was singled out to perform these duties, and by that he means additional duties, because of her sex. What the evidence was and is that all of the installer service specialists were required, or requested at least, to perform these tasks as time permitted. And there was one coworker in particular, whose name I will not use, who she said refused to perform those extra tasks, and that was a man. And what the evidence tells us is that that person was the most productive salesperson in the store, and he was very busy making sales. And so therefore, at least took the position that he did not have time to do some of the extra tasks that Ms. Elliott did perform. And it really is a difficult balance in that situation where you're basically saying to folks, you know, clean up or take care of extra tasks or do other things when you have the time. Some people have the time, others don't. And to be clear, O'Reilly, agrees with Ms. Elliott when she says that she was a dedicated, hardworking person. And so she was a person, in O'Reilly's view, and this was laid out in some detail in the fact-finding conference, who did not want to be idle when she was not on the phone. And so she took it upon herself to perform tasks that perhaps some of her male peers, one in particular, was not as diligent about doing. But that was not discrimination on the basis of sex. That was, frankly, one employee being more diligent than another. Ms. Elliott asked why the issue of her compensation came up during this investigation. And frankly, it comes up for two reasons. One is, as the commission is aware, this reduction in force occurred right at the beginning of the pandemic. And what O'Reilly was trying to do was to cut costs. And one way to cut costs is to look for where the highest compensation people are who can be spared. And the evidence is that the Farmington store where Ms. Elliott worked had 3 ISS employees, which was unusual, and she was the highest paid person there. And so that fact is relevant for that reason. It's also relevant, frankly, because it refutes the idea that she was a victim of discrimination on the basis of sex. The regional manager for O'Reilly, and just to be clear, that's really 3 levels up from Ms. Elliott. Ms. Elliott reports to a store manager, who reports to a district manager, who reports to a regional manager. The regional manager had gone out and affirmatively recruited her from another employer in the same town because of her extensive experience and because of the belief that she would be a very effective salesperson who could bring customers with her to O'Reilly. Now that didn't pan out. As it turned out, the customers didn't follow her apparently because she wasn't making great sales. But the notion that Ms. Elliott was a victim of discrimination on the basis of sex is simply inconsistent with the fact that O'Reilly went out and affirmatively sought her out to bring her into the company. That's not at all consistent with a company that intends to discriminate on the basis of sex. It is true, I think Commissioner Ashby asked about the reduction in force, and I think as the investigator's report accurately says, the reduction in force resulted in the attrition of both male and female employees, not only company-wide, but within the store. And so there was one male employee and one female employee laid off from the Farmington store as a result of this reduction in force. There were other male and female employees who remained after the reduction in force. And finally, I think to try to address Commissioner David's question about the culture issue, there's not a culture exam. There was there's an evaluation, frankly, of how well or how closely individual employees fit into the O'Reilly, what O'Reilly views as its culture, which typically involves things like polite communication with customers and some other factors. But the important one in this case was the communication issue and the interaction with customers. And I think, frankly, you know, Ms. Elliott was concerned about the fact that she was not criticized. That's not the right way to say it. I think what she suggests is that she was somehow blindsided because the evaluation she did have did not criticize her interactions with customers. But as she pointed out, that evaluation had happened a year or so before this layoff occurred. There was nothing about her interactions with customers that would have justified her in being disciplined. This is not a discipline case. This is not a situation where O'Reilly needed to engage in progressive discipline because in order to put her on notice that she needed to improve her interpersonal communication with customers.
Mr. Tainter,
Yes,
that's your time.
thank you.
I'm sorry to cut you off mid-sentence. Any commissioner questions for Mr. Tainter? I see one. Commissioner Ashby and then Commissioner David.
Hi, Attorney Tainter. On page 2 of the investigator's report, there's a finding of fact made at 3B that indicates complainant was tasked with additional responsibilities that other male employees did not do, such as making deliveries. And additionally, that the complainant was tasked to help train this new employee, which affected her ability to perform sales. Now, those findings are footnoted to reflect that your client doesn't agree with those findings, but you agree they're the findings of our investigator, right?
Yes, it's not clear to me when certainly I agree that those are findings of the investigator. I think there's some subtlety in them that I'd be happy to discuss if you would like me to. I'm not sure that he said that particularly the first one, it's not clear to me that the investigator said that she was the only one who was asked to do those things. That's one way to interpret it, but I'm not sure that's what the investigator meant.
No, I see that. I see that nuance. But I mean, we're going to be one way the commission can approach these findings is to embrace or adopt the findings of our investigator unless we're sort of convinced otherwise. And
true.
I'm wrestling with the fact that that's an actual finding. And you agree that if that's an actual finding, and if it is the case that she was tasked with these, now maybe this is a bridge too far for you, but if she was actually told to do things that male employees weren't told to do, that's discrimination, right? I mean, you would agree that that's the case, correct?
Well, I don't think it's discrimination on the basis of sex necessarily. It may be discrimination in the sense that we all discriminate every day in our lives on the basis of factors other than protected characteristics. And it may be because one employee is more diligent than another. And so you may, or I may ask my best employee to do things, or I may ask a whole bunch of people to do things, and one or two of them actually do them. And that's kind of what was going on here, I think, at least with regard to this one other male employee, who is the one that I think Ms. Elliott primarily complains about. And I think it's true that he said, I don't have time for that. And we certainly treat people differently depending on other characteristics. And the characteristic in this case may have been, look, I'm using a pseudonym here, John Smith is busy. He's selling 5 times what Philona Elliott is selling. He's on the phone all the time. He doesn't have the free time to go and do something on the computer or clean up around a particular area. But that doesn't mean that's discrimination on the basis of sex. And that's
what. No, I see that. I guess I see that distinction, right? I mean, it can be that it is the case that it just so happens that the person who is tasked with the unsavory tasks or the tasks that affect her ability to generate bottom line, it may be the case that it just so happens she's a female and that it's not otherwise intended to be discriminatory. I guess I get that distinction. I mean, her response might be though that it's not fair that you don't then pull the guy off the phone and say, listen, guy, you gotta go do deliveries, or you've got to go do this unsavory stuff, and give the complainant an opportunity to bring her bottom line up.
And it could be, I think we can agree that things happen in the workplace all the time that aren't fair, but that aren't discrimination on the basis of sex or age or disability.
I get
Now,
that.
the other thing that I think is worth mentioning here is that the evidence was, and it's not mentioned here in the report, I think, that Ms. Elliott always had access to a phone, that there was nothing about her going back to a back room or having to work on a computer or doing something else that prevented her from being able to answer a phone. And in fact, O'Reilly has what they call, and again, this is described in the record, but it's only in the report, a 3-ring policy where the idea is you need to answer the phone before it rings. Or I guess that maybe it should ring no more than 3 times. And there are multiple phones and multiple places throughout the business, throughout the company, for Ms. O'Reilly, Ms. Elliott to pick up the phone and answer it. And so these additional duties that she claimed she was doing should not have prevented her from doing that. That's obviously a factual dispute.
Great. Thank you.
Commissioner David, could you have a question?
Yes, thank you, Attorney Tainter. I'm in the next paragraph from where Commissioner Aspey was, paragraph C. It says that the RIF is the measurement that caused this decision. What's the total score out of which you get 21 or 22? Is it 30 or 100, or is that not in the record?
So it is in the record. Not sure that I've ever calculated it, but Exhibit I to I'm sorry, it's not Exhibit I.
What's the total metric, Attorney? What's the number?
I'm trying to find it here. No, I can't calculate it here.
Okay.
But it's Exhibit J. I'm sorry, and so one of the co-workers had a score of 38. Another one had a score of 22. It looks like it's not a very good copy, and I think Ms. Elliott was 20. It looks like.
The 21 is what the investigator found.
Okay. So
in paragraph
21.
C, and
Yeah, so 21.
It says that the RIF analysis measures productivity, evaluations, progressive discipline, tenure, and culture. Evaluations, we know, are not problematic. Progressive discipline does not exist. Tenure, she exceeds the other employment, and we have this business about culture. What in the RIF justifies her termination? Let me answer my own question in the sense that that paragraph by the investigator, and I need to challenge the investigator, says that the management talked to the store manager who said there had been complaints about rude phone behavior, which is footnoted with the fact that there's no evidence of that. So I don't see how there's a justification. The last sentence of that paragraph says management decided to discharge complainant because of her low evaluation score, which I'm seriously questioning, and her high hourly rate, which is not mentioned in the RIF at all as a basis for firing somebody, correct?
Well, the hourly rate is not mentioned, and certainly it's not mentioned in the calculus, but it's a perfectly logical factor for an employer to take into account when trying to reduce costs. I don't think that I think the footnote you're responding to, the footnote that you mentioned, footnote 5, says that the respondent did not produce documentation of the alleged customer complaints. But that's different than saying that there was no evidence of customer complaints. The evidence was information provided by the store manager during the fact-finding conference, and that evidence is just as valid and apparently was deemed credible by the investigator. So the fact that those complaints weren't documented in a small store is not particularly unusual, I would suggest. I think we all make judgments based on things we know that we haven't documented to a T. So there's no question it was a close call between Ms. Elliott and one coworker, but there is no evidence. And there's no evidence identified by the investigator and no evidence identified by Ms. Elliott today that discrepancy was due to her sex.
Usually seniority is a major factor in these kinds of decisions. Is it not?
I don't know what other companies do. As I look at this, it appears as though they had the same tenure rating. Again, I guess they weren't talking about, and I'm not sure whether you're focusing on Ms. Elliott's 28 years in the industry or her relatively short tenure with O'Reilly. She certainly had more seniority than the one person who remained, the one of the two people who remained at O'Reilly after the RIF.
That's what I'm focusing on, is that she had more than the one that remained after she was let go, and that's the allegation of discrimination.
Well, there are all kinds of factors that go into any employment decision besides tenure. And so that can certainly be one factor, but there's nothing to suggest that O'Reilly was wrong to give greater weight to other factors.
Okay. Any other commissioner questions at this time for Mr. Tainter? Seeing none. Thank you, Mr. Tainter. At this time, we'll go back to Ms. Elliott. Ms. Elliott, you have about 3 minutes left.
I would just like to point out when he mentioned that I had access to a phone, I did not have access to a phone when I was doing deliveries, as it says in the B section there, that I was tasked with doing that. When I'm away from the store for 3 to 4 to 5 hours doing deliveries, I do not have access to the phone. And I would have had more sales had I been allowed to stay at my station to do my job. But I was asked to do those other jobs. And him saying that my coworker sales were better than mine because he was wanted on the phone more. I was wanted on the phone too, but there was no way for me to complete the task that my employer asked me to do and be at my phone too. That it was just impossible. And him talking about me working out front, the distance to out front is great. It's not like I can just run back and answer the phone on the ISS line. And again, I was the only female out of 3. And to his point that my score was a 21 and my next closest employee was 22. He also was not fat. He also did not train the employee who was kept that had less time there than I did too. I had to train him. And again, that took away from my sales, from my production. And if I had had the opportunities to do what my male employee counterparts had to do, I would have obviously had much greater sales. And that's all I have to say. Thank you.
Thank you. Commissioners, any follow-up questions for Ms. Elliott? Seeing none. Thank you, Ms. Elliott. So at this point, we turn to the investigator, and as I think was pointed out, this was investigated by Milo Gitchos. Alex Brindley is presenting Milo's report.
Hello, everyone, commissioners. Again, my name is Alex Brindley. I did not investigate this case, but I inherited it from Milo Gitchos. So it seems to me that the crux of the issue in this case is whether or not the alleged additional tasks that were assigned to complainant led to her being laid off, and whether or not that was based on her sex. So it seems to me that there's no evidence that the complainant was the only one that was assigned to these additional duties. And even if she was the only one who was assigned to these additional duties, there's no evidence in the record that states that she was assigned to these duties because of her sex. So therefore, because of these duties, additional or otherwise, she failed to, apologies, there's a hair in my mouth. She failed to, complete her sales goals. And so that led her to being the one chosen for the reduction in force. Other than that, I'm open to any questions you may have.
Commissioner, questions for the investigator? I see Commissioner Whitworth and then Commissioner Ashby.
I'm not sure if this is for you, Alex, or if it's a better question for Barbara, but I have some concerns on page 3 of the report that goes into page 4. And I'm not sure exactly how to put this into words. How much weight should we place on the fact that the respondent, their methods and documentation are not a model of clarity? And we don't really know how this secret sauce is made, what the culture score is based on. I mean, anybody can fabricate anything given the fact that they're going to keep secrets about how certain things are developed internally. And it concerns me that even though the record doesn't contain any evidence that she was laid off because of her sex, there are a lot of unknowns that we're sitting in our chairs, at least I am, forced to make assumptions about, and not knowing what some of these scores are based on is very concerning from where I sit. So was that a question? So my question is, how much relevance or how much weight do we give the fact that we don't really have, or at least I don't, I won't speak for anybody else, but I don't really have a good sense of their scoring system, or how it was exactly determined that she would be the individual who would be laid off.
So based on my understanding of the record, it did look like Investigator Milo Gitchos did take that into account. However, based on the fact that there is no evidence proving otherwise, that she was, provided these additional duties because of her sex, or because she was laid off because of her sex, it wasn't ultimately relevant.
So there's nothing in the record then that indicates that she was tasked with, I don't want to call them administrative duties, but I will for the purpose of this argument, that she was tasked with administrative duties simply because she was female.
Correct.
So then we're left to draw our own conclusions, correct?
I believe so.
Okay, thank you.
I forget if Commissioner Ashby had his hand up before. I see Commissioner David.
I had my hand up, but Commissioner Whitworth excellently dealt with some of the questions that I had.
Okay, Commissioner David.
Yeah, and I fully agree. And I said, asking Attorney Tainter, that I was suspicious of this culture business. I'm suspicious of these scores. And by the way, there is evidence in the record that she was discriminated against, and it's her testimony. And this is going to come down to whether it's and even as likely or not that she could prevail. So I had said that I would ask the investigator, and I realize, Alex, that you inherited this, but of those factors in the RIF scoring, evaluations, progressive discipline, tenure, and culture, none of those suggest that she would be selected to be laid off. I guess the only one that's plausible is productivity in what I've heard about that scoring. My concern is that the scoring is soft, as Commissioner Whitworth says, we don't know how the secret sauce is made, that it allows them to make the decision they want to make. So how do you respond to that, Alex?
No, I definitely agree that the formula to the secret sauce is missing. Barbara, would you like to assist in this matter, if you can?
Yeah, I was just seeing if my phone was
lighting up because there was a text from Alex that said, there isn't, but here we are. Yeah, so I have read the record. I will tell you that this was a close case from the beginning, from my perspective. We know nothing at all about what the culture score could have been, that it turned out that there was this difference. And I do think you can draw whatever inferences you want from that. Ed, I'm not sure I remember what your actual question was.
Is that, Ed, was that your?
You're muted, Ed.
It was a challenge that the description of the RIF categories, none of them justify picking her over the less senior employee.
Right. And there's certainly nothing in the documentation that explains it.
Okay.
Any additional commissioner questions for the investigator? Seeing none. Thank you, Alex.
Thank you.
So commissioners, you have heard from the parties and from the investigator, and at this point we need a motion.
Well, I will move to not accept the recommendation of the investigator, and to move that there are reasonable grounds to believe that O'Reilly Auto Parts discriminated against Philona Elliott based on sex, and the complaint should be conciliated.
And I'll second that. Thank you, Deb.
So the motion is to find that there are reasonable grounds to believe that O'Reilly Auto Parts discriminated against Philona Elliott based on her sex. It's been seconded. Is there any discussion among commissioners? Oh, I see both. Oh, hold on. I see the three female commissioners all have comments. First, Commissioner Whitworth, then Doosan, then O'Brien.
Just want to go on the record as saying, because you don't provide information as an organization, doesn't give you a pass. That's why I'm going in the way that I'm going here. You have an obligation. As an employer, well, you have an obligation as an employer to make sure that everybody's clear about what the rules of engagement are. And again, relative to this secret sauce, doesn't give you a pass that you don't provide the information that makes it clear to employees what the rules of engagement are. Thank you.
Commissioner Doosan.
I am, having listened to my colleagues and the parties, I agree with or am convinced by the investigator's report that the complainant made a prima facie case, that there's burden shifting here, that in this circumstance where there's really a question of credibility and lack of clarity around the standards used by the respondent to make the layoff decision, I'm left at the better than even chance assessment, and I hope I use those words of art correctly in the right order. And I think that the complainant should have that the commission should rule in support of the motion.
Commissioner O'Brien.
Well, to me, and I'm a little concerned that I may be going down the wrong path, but to me, it's a huge leap from. I mean, I see nothing there. I agree with the commission, with the investigator's report, because I see no. I don't see a nexus between the fact that she is a female. There were three options, three employees, as I understand it, 2 males, 1 female. It's one of the 3, and I just see nothing to convince me that it's because she's a female.
Any other? Oh, yes, Commissioner Ashby.
I just want to clarify, I think I heard Commissioner Doosan use the phrase better than even, and I think it's an even shot.
At
not
least an
better
even
than-
chance.
Not better than even, and that's.
Thank you.
that's
That's why
a-
I hedged about using the words of art. Thank
Well,
you.
and I don't mean to be critical, I just want to make sure that when I vote for the motion, and I'm going to, it's because I believe she has an even shot. I'm not sure that the evidence shows that she has a better than even shot, but.
Thank you, Commissioner Ashby. I didn't want to jump in with that, even though I'm normally pretty pushy about that thing, but any other commissioner discussion on the pending motion? Yes, Commissioner David.
I tipped my hand in
Oh.
my,
Thank
my
you both.
questions,
I-
and I'm going to vote for the motion.
Yeah, I just wanted to interrupt briefly to thank you both. I invited that correction and I appreciate it.
Any other commissioner discussion on the pending motion? Seeing none. So the motion is to find reasonable grounds to believe that respondent discriminated against complainant on the basis of sex. If you say yes, you are in agreement. Commissioner Whitworth,
Yes.
Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner Doosan,
Yes.
Commissioner O'Brien.
No.
Okay. So the vote is 4-1. The finding is reasonable grounds. And the commission will send the parties and attorneys, party and attorney, a letter confirming that and inviting the parties to conciliation. Thank you both very much for your patience today. And now we have.
Yeah,
Thank
our
you.
last case of the morning. Case E20-0221, Judith Duke v. Sweetser. As a no reasonable grounds recommendation, we will ask the complainant to go first.
Ms. Duke is here. Ms. Duke, can you unmute your microphone? There you go.
Yeah, no wonder you couldn't hear me say good morning.
Okay, so you have 10 minutes, Ms. Duke.
Thank you. And thank you for listening to me. I have a few inaccuracies in the investigator's report, or my opinion of inaccuracies. In the summary of the case, first of all, I worked for Sweetser for 8 years, as on record. And I have never had a bad review until after I was already out of Sweetser. And in fact, I just had a raise just before I had to leave there. And in the summary of this report, where it says that I was discharged because of my age, that wasn't the case, and nor did I ever say that. I have never been discharged from Sweetser. And it also states that on the judicial data, that the date of alleged discrimination was 12/6/19. That is incorrect. That discrimination started back in that summer, or that early fall, I should say. And that date, 12/6/19, was the date that my job at that time would have been discontinued and had the opportunity to reapply. At the time, I was out on disability. My doctor put me out for an emotional state that I was in due to the constant gaslighting that I had been receiving from my supervisor. I shan't mention her name, but my supervisor and her supervisor were both brand new people who had never been supervisors before. So I, will give a pass on that. They were having a hard time too. But every turn that I made, starting from the beginning, when my co-worker and I were told that we would be cross-training to help out with if somebody was out sick and things like that, I have no problem with that. I always went above and beyond of learning new things. I also worked with the billing department when I was downstairs at the desk. And so I had both those jobs going at the same time. Not at any point until probably about a week before I left were we told that this was going to be a permanent position upstairs. It doesn't matter what you call it, customer service, admin support. My title had changed back and forth and went 5 or 6 times in the 8 years that I was at Switzer. I loved my job. I loved clients and the people I worked with. My supervisor, oh, excuse me, I knew I was going to do this 2 years later and I'm still trying double. She was a very difficult time of learning the new things for the new position, across training, for 2 reasons. Number one, we had a brand new computer system, which my supervisor and everybody in the organization was learning. Nobody actually knew what was going to go on with it at the time. The other thing is to go from my downstairs position to upstairs on a daily or half-day basis. I would have to take all my work that I was going to be doing for downstairs and to upstairs, wheel it up in a chair down the hall because we were not provided adequate seating upstairs. I'm a large person and I needed a chair that had a little bit larger bottom in it than what was upstairs. Even though the one that I was taking up with me was raggedy, it was still, it still was usable. I was promised a new chair and I never did get that, but that was part of my complaint. The biggest thing is my supervisor, no matter what I did, I was told, you ask too many questions. You forget things. Maybe you're too old to remember this. Maybe you should retire. All those things I spent months putting up with. At first, I thought it was a joke, but it wasn't a joke. The days I left Switzer for the last time, I knew that if I had to go in another day at that point, that I would have probably blown up or something very unpleasant to that effect. I've never had a complaint of talking inappropriate to our clients until this. When I asked what I said that was inappropriate, my supervisor's comment was, I don't know. And then I said to her, how am I supposed to not say it if you don't tell me what I said? And I never got an answer. And that really played on my head bad because the clients that came in there, always said that I made a difference. And I felt I did. I cared about the client. And still do, as a matter of fact. Anyway, to continue. I'm back to the, a lot of the things are that my coworker was out on leave due to she had an illness, and it stated in one of the reports that the coworker was still there after I had left. Absolutely, she was. She knew that she was. I know I shouldn't be saying what she knew. I watched Judge Judy enough to know that really is admissible. But she was being treated just about the same way I was. The only difference being she'd been out of work for over a month and didn't have to put up with it. And also, it was known to everybody in the facility that her brother-in-law is the president of another mental health facility in the area, and her sister was the vice president. I don't know whether that had anything to do to the fact that she wasn't getting quite the same treatment as myself. I do know that shortly after I left, that she also left, but she could choose to retire. She retired one day and started looking for a job the next because she was unhappy, and she was there 15 years. That says a lot. I know I'm forgetting probably a lot of stuff that I should be telling you, but I had it all written down, 4 pages worth, and I can't even, I can't remember what else. I just know that the way she treated me, and I had to go out on leave. When they asked me if I wanted to apply for the job that was coming up after being laid off, after I was in no position to. I was in no position to. If I had to go back and work with that same person treating me like that, nor do I think that they would necessarily have hired me. Not if it has changed my whole life. I don't even leave my house. I spend every week going to a counselor and my doctor. She broke me. I worked for, I was 72 years old. I figured I had another 5 years because I loved my job. In all the 72 years, 50 or plus of them I've been working, I have never been treated like this in my life. I don't leave my house. She's made me feel inadequate, stupid, and too old to have any idea of how to do anything correctly. It was impossible, but there was no, excuse me.
Ms. Duke? Ms.
I'm
Duke?
sorry. Yes.
I'm sorry to interrupt you, but actually you've reached the end of your time.
Okay. Thank you.
Okay, can you, while you're collecting yourself, I'm going to ask the commissioners if they have any questions for you. If commissioners have any questions for Ms. Duke, if you could just raise a hand and I will call on you. And none of the commissioners are raising their hands with questions, Ms. Duke, so we're going to turn and hear from Sweetser. All right, I'm going to mute you just because your time to present is up. Thank you. Ms. Olivier.
Thank you. Good morning, everyone. I'm Betty Olivier, and I represent Sweetser. And Ms. Duke, I just want to tell you that, you know, it's unfortunate, and we feel sorry that you are so upset about the loss of your job. But what I can say, and what the record makes clear, that there were really 2 decisions that Sweetser made that form the basis for your claims. Neither of them.
Ms. Olivier, I would just ask you to present to the commissioners and not directly to Ms. Duke.
Okay.
Thank you.
Thank you. My apologies. Neither of these decisions was directed to Ms. Duke directly or personally, and neither of them impacted her exclusively. The first decision involved a consolidation of the customer service position and the receptionist positions into one role. At the time this decision was made, which was the spring of 2019, there were only 2 employees at Sweetser who were serving as receptionists exclusively. One was Ms. Duke, and the other was her co-worker, who Ms. Duke has referred to in her complaint, who also happened to be around 70 or a little over 70. But the age of these individuals had nothing to do with this restructuring that was taking place. Sweetser was experiencing some operational changes, some staff turnover, and it had a need for additional support in the customer service department. It also had determined that it could no longer sustain full-time receptionists because the receptionist role was really not a full-time job. It didn't terminate the employment of the receptionists. Rather, it gave them the opportunity to learn new skills, so to cross-train so that they could provide the support that was needed on the customer service team. And that would actually make them more marketable, both within the organization and without. This was an entirely legitimate change and restructuring that was taking place, and cross-training people so they can do other jobs is not adverse action. One of the bases for Ms. Duke's allegations that this was discriminatory on the basis of her age is that Sweetser moved a younger female to the front desk position where Ms. Duke was previously located. And that happened because for Ms. Duke and her coworker to cross-train and learn the new skills, they had to be upstairs on the second floor in this building for a period of time. That's where some of the locations were, that's where the direct supervisor was located, and it just provided a better opportunity for the kind of cross-training and oversight that was necessary. Initially, Ms. Duke and her coworker were rotating between floors, but they complained about having to do that, so Sweetser made the decision to move them to the second floor exclusively while they were going through this training. Sweetser had three choices in terms of moving someone to the front desk location. One of the employees was a male in his 50s, but he was an intake coordinator. It was a higher skill job. He had been highly trained, and it just didn't make any sense to move him and then have to train someone for the intake coordinator position. The second option was a temporary employee who hadn't been trained in the receptionist work and was only going to be with Sweetser for another month. So that was an option that really didn't make sense. And the third and final option was a woman in her 30s who actually did not want to move down to that location, but agreed to do so to just assist Sweetser as it was going through this cross-training and restructuring. Ms. Duke has made an issue, I believe, in her argument that her supervisor treated her poorly or unfairly. Again, there's no evidence that age had anything to do with the oversight that she was being provided. It is true that the supervisor determined that Ms. Duke was struggling learning some of the duties. There were concerns about some of her interactions with clients. She was very vocal with clients and with other people about her unhappiness at being moved and having to cross-train. And the supervisor did address that with her. There are the supervision notes that are included in our submission depict some of those discussions. And it's constructive criticism, it's encouraging. She really wasn't treated poorly or unfairly. And it was really just an effort to get her to a point where she could do the job that she needed to do. Ms. Duke also claimed in her objection to the investigator's report that there's someone else who's now sitting at that front desk position on a permanent basis, apparently arguing that that supports her age discrimination claim. But the person who's sitting at that front desk is filling the access coordinator position, and that person is performing multiple tasks. It's not exclusively a receptionist role. And the tasks that are being performed by that person are the same tasks that Ms. Duke was being cross-trained to learn and perform. So there's no basis for finding age discrimination around this whole cross-training issue. Her employment wasn't terminated. She was cross-trained and taught new tasks, and cross-training with the goal of moving someone to a new position isn't something that an employer does when it's trying to eliminate somebody on the basis of age. The second decision that's at the heart of Ms. Duke's claims was a decision that was made to close the outpatient department. And this decision was made by someone far higher up in the chain of command at Sweetser than Ms. Duke's direct supervisor. The closure of that program eliminated the need for administrative support. This closure affected 16 people in the customer service department. Everyone in Ms. Duke's department was impacted by this and was at risk of being laid off. They were all told they could apply for this newly created position. It was the access coordinator position, which was going to be a combined customer service role and the role of an individual who had served at a promise line, on the promise line. Ms. Duke was out on medical leave at the time that the decision to close the program was made. But Sweetser reached out to her. They let her know about the pending layoffs, and they also recommended or suggested that she apply for the access coordinator position. She declined to do so. Her coworker, who she's mentioned, the other woman who was in her 70s, was given the same opportunity. She applied for the access coordinator position and was given it. And there was a vacancy in that position. So it's quite likely that had Ms. Duke applied for that position, she would have been given the job. You know, it's true that Ms. Duke struggled and was unhappy that she had to move to another workstation, but sometimes employers just have to make difficult decisions to sustain the financial and operational viability of the business. And that's all that was going on here. There's absolutely no evidence that Ms. Duke was impacted because of her age. There's no basis for finding Sweetser liable for any type of discriminatory conduct, and I respectfully request that the commissioners affirm the decision of the investigator that there's no reasonable grounds to find discrimination. Thank you.
Thank you. Any commissioners who have questions for Ms. Olivier, raise your hand and I'll call on you. Commissioners with questions? Seeing none at the moment. And Ms. Duke has used her time. So at this point, we would turn to the investigator. And like the previous case, this was a report by investigator Milo Gitjos that another investigator is presenting. Jane?
Morning, commissioners. My name is Jane O'Reilly. As Amy just mentioned, I was not the investigator on this case, but I have read the record and the report as well as the submission of disagreement, and I'm happy to answer questions.
Any commissioners have questions for the investigator? If so, raise your hand. I see Commissioner Ashby. I believe that's the only question at this point. Commissioner Ashby?
Yes, I'll be brief. The complainant made reference in her written response to the investigator's findings that her supervisor implied she was too old. She used stronger language today in her statements that her supervisor said something to the effect of her being old, or maybe why doesn't she retire? I think I'm paraphrasing, I think those are the words. What does the record say about actual statements that exhibit discriminatory animus? Was there, first of all, were there such statements referenced in her complaint, if you know? And then did she make those comments in the course of the investigation, if you know? The reason the investigator's report is silent as to that. There's no reference to the statements to that effect.
Correct. And I'm looking at the complaint right now, just to be sure that I state correctly. Okay, yes. So the record does not contain the specificity of these types of statements. There's a general statement and report from complainant that the tasks she was being asked to do, she was told she asked too many questions, but most of her initial submissions focused instead on the having to move to a different location, and the fact that she had to move back and forth was unpleasant, and the fact that the younger woman was replacing her at the front desk. Those were the main points of the claim initially that was looked at by Milo as he investigated.
Great, thank you.
Any other questions from commissioners for the investigator? Seeing none. Thank you, Jane. So commissioners, we've heard from the parties and from the investigator, and at this point we would be looking for a motion.
I'll move to uphold the recommendation of the investigator that there are no reasonable grounds to believe that Sweetser discriminated against Judith Duke based on her age, and the complaint should be dismissed in accordance with the act.
Second.
So there's a motion to find no reasonable grounds to believe unlawful discrimination occurred. It's been seconded. Is there any discussion among commissioners? Seeing none. So commissioners, the motion is to find no reasonable grounds. If you say yes, you are in agreement with that. Commissioner Whitworth,
Yes.
Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner Dusan,
Yes.
Commissioner O'Brien. We need to be able to hear you, Commissioner O'Brien.
There we go. Yes.
Okay, so the vote is 5-0 to find that there are no reasonable grounds to believe unlawful discrimination occurred. The commission will send the parties and attorneys a letter confirming that, and thank you all for being present today. I think that is the end of our morning agenda, and I think we have 10 minutes to spare before we start our afternoon agenda.
So everybody, please come back at noon promptly, and we'll listen to our final two cases.
Thank you all very much. We'll see you in a few minutes.
Okay, I think we're all here. So we'll get started with our afternoon session. Good afternoon. I'm Deb Whitworth, and on behalf of my fellow commissioners, welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking each of you who may have an electronic device, cell phone, pager, etc., to ensure that they're silenced now. You have been provided with an agenda and a consent agenda available on the Human Rights Commission website. Please refer to that if you need to. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted period. The commission has voted on those cases and they'll not be considered further today. The remaining cases on the agenda are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time frame. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only relevant factual errors, relevant omissions from the report of facts submitted during the investigation, or relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that commissioners may ask questions, and please introduce yourself as you're called to present your case. Thank you.
And just want to remind everybody not to mention the names of any third parties or witnesses. The Maine Human Rights Act requires us to maintain their names as confidential. We've given pseudonyms in our reports. Sorry, go ahead, Deb. Sorry.
No, thanks. So the first case this afternoon is H21-0196AB, Johannes Selassie v. Mark Fortin and Michelle Fortin. This is a reasonable grounds recommendation. So is there anybody here for the respondent?
I think Mr. Patient, is that you?
Yes, Greg Patient for the respondents, Michelle and Mark Fortin.
Okay, you have 10 minutes.
Very good. Do I have an opportunity to share my screen?
No, not unless you tell me first what you're going to share.
Very good. Okay. Thank you. I appreciate the opportunity to address the commissioners. I think a consideration of the timeline and written documents exchanged in this case establish that there is no basis for a reasonable grounds finding that the Fortins discriminated against Mr. Selassie on the basis of his religion. If I could, I'd just like to walk the commissioners through a handful of dates. The first being a June 1st, 2020 date when Mr. Salassi executed his lease. The lease provided a lease term through May 30th of 2021. The lease provided that for the tenant to remain in the residence after that period required the consent of the landlord. The lease also had a number of provisions that included that the tenant would not damage the building or grounds, that the tenant would not make alterations to the building without prior written consent of the landlord, that the tenant would not use screws to hang things on the walls, and that no holes would be made in any woodwork. With respect to parking, the lease provided that a tenant could not keep a trailer at the property without the prior written consent of the landlord, and that any such vehicle parked there without the landlord's consent could be towed at the tenant's expense. The lease also provided that a violation of a provision of the lease, that upon such a violation, the landlord could serve the tenant with a 7-day notice terminating the tenancy, and that it was at the landlord's discretion as to whether or not to give the tenant an opportunity to cure any breach of the lease. So that's the lease in as it stood in June 1st, providing Mr. Salassi's term through May 31st. In February, the Fortons emailed Mr. Salassi that they did not intend to renew his lease. There had been incidents involving rent payments, Mr. Salassi's cooperation, conflict between Mr. Salassi and contractors that the Fortons had at the site. Mr. Salassi had planted trees at the property despite Ms. Forton's express written direction to him not to plant those trees. So those were all some of the grounds on which the Fortons elected not to renew Mr. Salassi's lease and to provide him notice of that in February 3rd of 2020, written notice. And again, on March 4th of 2021, Ms. Forton emailed Mr. Salassi, again, reminding him that his lease ended on May 29th and would not be renewed. In both that email and the February email, Ms. Forton advised that the trailer, Mr. Salassi had a trailer at the property that the Fortons had originally provided permission for him to have there, could no longer be at the property because they intended to have some contractors at the property doing work, and that he needed to relocate it by April 1st. On March 21st of 2021, Mr. Salassi relocated the trailer. The next morning, Ms. Forton discovered that his relocation of the trailer had caused significant damage to the lawn. She advised Mr. Salassi in writing that she expected he would be responsible for the cost. All of this takes place before April of 2021. Mr. Salassi has been informed that his lease will not be renewed. There have been issues with respect to damages to the property that Mr. Salassi has been notified about. The investigators' findings indicate that in April of 2021, and there's some dispute as to when this occurred in April, but both parties certainly agree it was in April, that Ms. Forton noticed what she thought was a metal object affixed to Mr. Salassi's door frame, and which we know to be a mezuzah. On April 15th of 2021, and I should note that at that meeting, Ms. Forton says she noticed it on April 7th when she went to the property to replace some batteries. At that point, there was no discussion of the religious significance of the mezuzah. On April 15th, Ms. Forton sent a letter to Mr. Salassi indicating that she noticed a metal object affixed to the outside of the door, that she had not provided written permission for the object to be affixed to the building. And that same email again asked that noted that Mr. Salassi had moved his trailer and damaged the lawn. That notice used language about providing 45 days for the termination of the tenancy. It was sent on April 15th, which would essentially have provided Mr. Salassi through May 30th, the precise day the tenancy was to expire and of which he had been notified would not renew. So no premature or advanced termination of the tenancy attempted. On April 22nd of 2021, the Fortons provided Mr. Salassi with an invoice for the damage to the lawn created by the trailer removal and asked that he pay it within 7 days. That invoice was for $750. That notice did not include any mention of the mezuzah or the metal object. On May 4th, 2021, the Fortons again sent the same letter as they sent on April 22nd of 2021, again mentioning the invoice, no mention of the metal object or the mezuzah. On May 6th of 2021, these Fortons advised Mr. Salassi that he was in default of the lease because of damages caused to the property. They cited 2 lease provisions pertaining to the grounds. Again, no mention of the mezuzah or the metal object. Mr. Salassi filed his complaint with the commission on May 10th. There's some question as to when the Fortons received notice of that, either May 13th, May 14th, or May 18th. On May 14th, the Fortons sent Mr. Salassi notice that he had not paid the invoice with respect to the damage to the grounds and asked him to provide 7 days to notice to quit. On May 18th is the first time that there is any documented discussion of the religious significance of the mezuzah. Mr. Salassi sent an email at 10 p.m. on May 18th. In that email, he discusses his faith, his belief, the purpose of the mezuzah, and he states, "I forgot to make an additional request." He then goes on to ask if the Fortons will accommodate his placement of the mezuzah on the entry door. At 10:42, 42 minutes later, Ms. Fortin replies saying, "The mezuzah was never an issue. It was using screws to the building that was the issue. The lease requires our written permission. Having your mezuzah is not a problem." Mr. Salassi stayed at the property through May, or actually into June, I believe, a couple days into June of 2021. He was not evicted early. The mezuzah was never removed from the door frame. And again, there was no request for any type of accommodation until May 18th, which is the day the Fortons learned of the religious significance of what before then to them had just been a metal object affixed to the door. When they learned of the significance of that, within 42 minutes, Ms. Fortin responded that the mezuzah was not an issue, that it was not a problem. Based on that timeline, that chronology, the Fortons contest the finding or the recommendation of the investigator that there be a finding of reasonable grounds of discrimination on the basis of religion. Again, I do not think there's any evidence in the record of that. And further, there is certainly no evidence of any request for accommodation until May 18th, which request was promptly agreed to. Thank you very much for your time and your consideration.
Thank you, Mr. Patient. Any commissioner questions for Mr. Patient? To raise your hand and I will get to you. I see Commissioner Ashby and Commissioner David. Commissioner Ashby.
Attorney Patient, your presentation didn't focus on, unfortunately, on what I'm concerned about, and I'm curious as to what you think about the investigator's extension of the reasonable accommodation concept to religion and housing. Do you have thoughts about that? About the propriety of extending the idea that a reasonable accommodation is something that can be requested and required in a housing case for a
I
religious-
confess, I looked up a few cases on that, Commissioner Ashby, and the cases that I found suggested there is no requirement with respect to reasonable accommodation for religion in housing. So my view would be that finding would be a stretch and an expansion of Maine law that certainly hasn't been countenanced by the legislature in its drafting of the statute.
Well, I had prepared a hypothetical, assuming you'd give a full-throated opposition to the application of the doctrine to reasonable or to housing and religion. I prepared a hypothetical. What if a tenant, assuming there's no bad blood, no anticipated denial of renewal of lease, no trailer that destroyed the property, but just assuming that it's a regular tenant with a regular landlord, and the tenant asks to affix a mezuzah to the outside of his or her residence in accordance with religious beliefs, would the landlord be required to accommodate that request if it was a reasonable request? Put aside this concern about holes in the siding as well, for that matter.
I would say under the current state of the law, no. Is there certainly a discussion to be had about whether we should consider requiring landlords to make reasonable accommodations for something like that? Sure, definitely. The Fortons here have talked about the possibility that Mr. Selassie could have used either some sort of glue or two-sided tape. I mean, there were methods in which this could have been affixed without causing damage to the property.
If I could just interject, and I don't mean to step on what the commissioners are doing, but I'm not sure any of this is in the record, so it's a pure hypothetical.
Well, the investigator's report references the application of the doctrine, although not stated in Maine law, applies the doctrine for the first time here. And so I think that asking hypotheticals to explore the legal appropriateness of doing so is entirely appropriate. I'm also not asking for a recitation of any facts outside of the record. I'm just doing what all appellate judges in arguments do. But nonetheless, I'm done questioning this attorney on this. Thank you.
Yeah, I was really mostly going to the idea that glue would have been fine when I don't know that came up.
Thank you. No, I guess I think I invited that we could discuss the reasonableness of whether or not attaching a mezuzah with screws versus glue was appropriate. I think I probably invited that response, Amy. Thank you, though. Thanks for the clarification.
Other questions? Commissioner David, I think you had a hand up.
Yes, two questions, Attorney Patient. Do the landlords have to give any reason at all for their plan to non-renew the lease? That's the first question.
The lease does not require them to provide any reason at all.
Does the Maine Human Rights Act?
I would, to the extent that there was a non-discriminatory reason provided before the Fortons had any notice that a mezuzah had been hung, I certainly don't think there's any issue with them providing as a reason the damage to the property that occurred in March of 2021.
And the second question is, you said you wanted to emphasize the timeline. I agree. I'm troubled by the timeline and when the mezuzah is noticed. But is there a factual disagreement here as to whether the Fortons are on notice of his religion? And does it matter?
I don't think that there is evidence in the record, Commissioner David, as to when the Fortons were on knowledge of or had knowledge of Mr. Selasi's religion. I do think the record is clear from both parties that the first time the Fortons had knowledge of the mezuzah being affixed to the building was in April of 2021, again, well after the notices had been provided with respect to the damage to the grounds.
And I'm sorry, there is a third question. Do we have a measure of the magnitude of the alleged damage from the trailer to the lawn and the repair, or is that in the record?
I believe that there are photographs affixed to one of Ms. Fortin's emails that are in the record showing the damage to the lawn. There's also an invoice. The invoice estimated $750 in damage for reseeding and loam of what are some pretty clear deep tire tracks leading off the property where the trailer was driven.
Any other questions from commissioners for Mr. Patient?
Before we move on, I just wanted to jump in. Commissioner Ashby, to the extent you are suggesting, which I think you did, that this was the first application of the doctrine of religious accommodation in housing, it is not. The commission has had quite a few of these cases, and we have applied this doctrine before.
Before we move on, then let's clarify that. I'm looking at the investigator's report at page 3. It indicates there are no cases that have interpreted the Human Rights Act to require housing providers to accommodate an applicant's or tenant's religious beliefs. How do we square what you just said with that statement?
There are no court cases. I'm saying the commission has had these cases and has consistently applied the right to a religious accommodation.
Thank you. So were they reasonable accommodation cases, Barb, or were they just straight up religious discrimination cases? Because of course there's a difference, right?
Of course there's a difference. And I believe we've had both cases in which people claim that they were not rented to because of their religion, but also cases where people wanted exceptions. For example, I can think of one where there was a no candles or fire exception and some rule, and somebody asked for an exception because their religious beliefs required them to burn incense. So that would have been an accommodation request. That's the one that comes to mind off the top of my head. I mean, I could do a search, but people would have to watch. That's the one I remember, though.
That's helpful. Thank you.
Sure.
I hope that predated my arrival at the commission. If it didn't, I'm a little embarrassed I didn't recall it.
That's okay. You listen to many, many cases.
Any other questions for Mr. Patient from commissioners before we turn to complainant? Seeing none. Thank you, Mr. Patient. You have used all of your time. So then we're going to turn to, I believe, Mr. Randall.
Good afternoon, commissioners. My name is Chet Randall with Pine Tree Legal Assistance, and I am here on behalf of Johannes Selasi. Before I jump into my prepared comments, I want to address a few issues just raised. First of all, I want to point out that Exhibit B attached to the respondent's objection to the investigator's report is in fact a notice to terminate. It is not an email. And it clearly states that the intent of that notice provided to Mr. Selasi was to terminate the tenancy immediately, not by the end of May as counsel suggested, but immediately. I'll also like to note that the record is filled and the interviews involved a fairly robust discussion about any damage to any lawn. And I'll point out that Mr. Selasi throughout the record indicating willingness and ability and capability because of his professional background to make repairs to the lawn that were refused. I'll also point out that the area Mr. Sellers produced significant evidence that the area complained was damaged was actually eventually used as a staging area for construction being conducted by the Fortons soon after the complaint was filed, or at least several months within the filing of the complaint. And then lastly, I'll now turn to my more prepared comments. As you all know, this case involves a finding of discrimination when the respondent sought to evict Mr. Selassie, who was Jewish, because he placed a mezuzah on his exterior door frame. The mezuzah, as Mr. Selassie made clear to the Fortons, is a requirement of his faith. By way of introduction, Mr. Selassie is a 2017 retired veteran of the United States Army. All of this is in the record. He served in combat in Afghanistan for a year. He deployed on humanitarian missions while enlisted. He now works for the United States Veteran Administration. He holds a bachelor's degree from the University of Texas at San Antonio, currently pursuing a master's degree in business while working full time. In this case, during the investigator's interview of the respondents, respondent Mark Fortin noted or stated that he believed Mr. Selassie to be lazy. Mr. Selassie is anything but lazy. I want to take a few minutes to address several of the arguments raised here by the respondents. First is the dispute related to the timing when Mr. Selassie placed the mezuzah. Mr. Selassie placed the mezuzah in February, not April. Mr. Selassie made that clear in the record. Mr. Selassie advised in writing and orally during the investigation that he placed the mezuzah on his doorframe in February after receiving one in the mail because he had not brought the mezuzah from Texas when he moved from Texas to Maine. The investigator's findings are accurate regarding the date Mr. Selassie placed the mezuzah on the door casing. The investigator interviewed the witnesses and reviewed all the evidence. During the interview process, the investigator had a chance to make determinations of the weight to give evidence, determine the quality of the evidence, judge the character and value of the oral statements, and measure the truthfulness of the evidence. The investigator did that here and concluded that Mr. Selassie placed the mezuzah on the door in February. Mr. Selassie made clear the purpose of the mezuzah, and only after the Fortons learned of the purpose did they seek to evict before the expiration of the lease. During oral statements made during the interviews and investigation by the investigator here, Mark Fortin acknowledged seeing a metal object attached to the door frame, but took no action to tell Mr. Selassie that he needed to remove it because of damage to the property. Only after Mr. Selassie advised Ms. Fortin of the meaning of the mezuzah in April did they proceed to demand he vacate the unit before the expiration of the lease. Mr. Selassie advised, and this is in the record, Michelle Fortin on April 1st that the mezuzah is a symbol of his religion. 1 week later, she again visited the property, told him to remove it, and he explained again that it was a required symbol of his faith and required to be placed at the entrance door. On April 15th, Michelle Fortin again visited the property and told Mr. Selassie to remove it. He again told Ms. Fortin that the mezuzah is a required symbol of his faith and he could not remove it. That also is in the record. She gave him a notice terminating the tenancy, asserting that the tenancy is ended immediately. I ask you to please see Exhibit M attached to our reply, but also Exhibit B attached to the objection to the investigator's report. That notice clearly terminates the tenancy immediately. Clearly, the reason for termination of the tenancy before the natural expiration of the lease is the mezuzah. The Fortins next complained that there was no written reasonable accommodation until May of 2021. However, Mr. Selassie did describe the importance of the mezuzah to his faith and the requirement he kept it at his door. There is no special language a person must use to request a reasonable accommodation. Although not strictly applicable here, the 2004 joint statement of the Departments of Housing and Department of Justice on reasonable accommodations in housing under the Fair Housing Act are instructive. The joint statement has been cited many times by courts. There, the agencies state at page 10, paragraph 12, that nothing requires a reasonable accommodation to be made in a particular manner. The person does not need to mention a statute or law or use the words reasonable accommodation. If the need for an accommodation to a rule or policy is readily apparent, that should be sufficient. The request merely needs to be made in a manner that a reasonable person would understand to be a request for an exception, change, or adjustment to a rule or policy. Mr. Selassie's explanation of the purpose of the mezuzah and the significance and importance of keeping it there is clearly an explanation, quote, that a reasonable person would understand to be a request for an exception, change, or adjustment to a rule or policy. While not written, while not written, Mr. Sellecy's exchanges with Ms. Ford are sufficient to put her on notice that he was asking for an exception to their policy. The Ford's next complained that the accommodation was not requested before Mr. Sellecy installed the mezuzah. It is important to note that a request for reasonable accommodation can be made at any time. Courts applying the FHA, the Fair Housing Act, and I'm referring to it as instructive, acknowledge that the federal statutes does not require that the request for reasonable accommodation be made at any particular time. Quote, under the Fair Housing Act, unlawful discrimination occurs whenever a dwelling is denied to a renter because of that renter's status. Under federal case law, interpreting that provision, a discriminatory denial can occur at any time during the entire period before a tenancy is actually evicted, or rather a tenant is actually evicted, end quote. And that's a quote from Douglas versus Creeksfield, a Washington District Court decision, federal court decision. Courts have found that a reasonable accommodation must be considered even after a policy is violated. And for that proposition, I rely in part on Housing Authority of City of Bangor versus Mayhew, but also Roe versus Sugar River Mills Associates, a district court decision in New Hampshire. Ms. Fortin appears to state in a written objection to the investigator's report that a reasonable accommodation was not appropriate because of the financial hardship resulting from the holes in the door trim caused by the screws. The investigator found the holes were minor. The photo included in the record support that conclusion. The photos in the record show Mr. Sellecy holding up a penny to the mezuzah. That helps provide you an understanding of why the investigator is correct, that the holes are minor, because that photo demonstrates how indeed very small those screws are. There are claims by the Fortins that there were other reasons for terminating Mr. Sellecy immediately in April. There is alleged damage to a lawn, failure to timely pay rent, failure to move a trailer when requested. The investigator heard and received evidence related to each of these. Mr. Sellecy refuted each. For instance, the Fortins complained that Mr. Sellecy's rent was not paid on time. However, the record shows that he paid within a day or two of the first of the month every month. The record reflects that he purportedly damaged lawn and was, however, as I pointed out a minute ago, the lawn was actually used as a construction staging area for a property the Fortins were building very close by, and there were photographs of heavy trucks parked in the very same place. There is no mistake in the timeline. There is clear evidence that Mr. Sellecy's religion played a significant role in the landlord's decision to terminate his tenancy early. The reason to terminate early in there is in the very notice to terminate the tenancy immediately on April 15th. It is in fact in the second or third line of that notice. Finally, the investigator found that independent of whether there was reasonable accommodation, the respondents commenced the eviction process against Mr. Sellecy because of his religion. I want to point out that the notice of termination is the first step required under Maine law to evict a tenant. That can be found at 14 MRS 6001. Without that notice, a landlord may not take any further action to have a sheriff remove a tenant or to proceed to court. To argue he was not evicted is only to say they did not finish the task, but they clearly took the legal steps to evict, and their clear intent was to persuade Sellecy to leave, which is the purpose of a notice of termination of tenancy. And I am, those are my comments. I welcome your questions. Thank you.
Thank you, Mr. Randall. Commissioner questions for Mr. Randall. If you have any, raise your hand, I'll take a look. Commissioner David.
Attorney Randall, the April 15th notice of immediate to terminate, is there a formal notice other than that, or is that what you're saying is the notice that changes the game from saying we're not going to renew at the end of May to we want you out now?
That is the notice that I'm relying on, sir. The Commissioner David, the Exhibit M or the Exhibit B to the respondent's objection clearly states that in the last sentence, your tenancy is immediately terminated. And in the very second sentence, the line of that, and if I could just have a minute.
Yeah, no, I see. I'm looking at it, and it says you've attached to the outside of the building. We did not okay any objects to be attached. So at that point, they're complaining about the mezuzah.
Commissioner David, I'm looking, I think maybe something different. It's the April 15th letter addressed to Johanna Selesi, attached as Exhibit B to the objection. I noticed that you mailed a metal object to the outside door frame. Is that the same notice?
Yes.
Okay.
Is that the notice you're saying?
Yes.
They were changing the game and that part of their motivation was religious discrimination?
Correct.
Okay.
And then at the very towards the second to last sentence, we're serving a termination of tenancy at will immediately.
Right. I understand that. And I tend to agree that is upping the ante. Had they not sent that at all and just relied on their notice, we're not renewing your lease, you would say there had not been any discrimination, right?
I think I would have less significant evidence to prove that, sir. Yes, that's correct, Commissioner David.
Thank you. Thank you.
Any other questions from commissioners for Mr. Randall? Seeing none. Okay, thank you, Mr. Randall. Before we move on, any questions for Mr. Patient before we go to the investigator? He doesn't have any time, but I just figured I would give commissioners one last opportunity. Seeing none. Okay. We go to the investigator, Ms. Brindley.
Good afternoon, everyone. I'm still Alex Brindley. I was the investigator in this case. At this time, I don't have any comments to make, but I am open to any questions as usual.
Any commissioner questions for the investigator? Commissioner Ashby.
Thank you, Alex. I'm really wrestling with at your investigator's report, page 4, paragraph 6. Using the employment analogy, you reference employment law and indicate what's required for showing for an accommodation denial in violation of the law, and indicates that the complainant need to have called the religious observance or practice to his employer's attention. And then you footnote that by saying there's a dispute in the record. This is footnote 3. There's a dispute in the record as to whether the complainant told the respondent that he's Jewish, but then you say elsewhere that, or maybe within this footnote, that it's kind of apparent that he's Jewish based on his wearing a yarmulke. And then you say that he informed them, and then he informed them on at least one occasion that he's Jewish. But you don't reference that he informed them of the religious observance or practice. Now, I just heard Attorney Randall say that the record has pretty good evidence that the complainant advised the respondent of the actual observance and that thereafter was given this eviction notice. Can you help me sort of understand that? Because I would suggest that if you wanted to make a claim for accommodation, letting the respondent know that he's Jewish is really not enough, right? I mean, I think he would need to indicate that he has this observance or practice that he wants to undertake and then see what the response of the respondent was.
You are correct, and I'm sorry that wasn't clear in my report. There is, at least in the record and in the Issues and Resolutions Conference held with the parties, there is indication that the complainant informed the respondent of his religion and that the mezuzah was important or was required for his religion. So it was a religious practice.
Prior to the April 15th, because I share Commissioner David's.
Correct. So there were 2 instances in which Michelle Fortin noticed the mezuzah before April 15th. I believe it was the 1st and the 7th. I could be wrong with the dates, however, and she acknowledged during the conference that she was aware of the religious significance of the mezuzah.
That's very helpful. Thank you so much.
Any other commissioner questions for the investigator? Commissioner David.
Alex, you don't question, but what they had the right to terminate the lease in February when they gave notice that it was not going to be renewed because of the damage of the trailer and the lawn and refusal to deal with that, correct?
Correct. It was more the fact that they sped up the termination of the tenancy immediately as a result of the mezuzah.
I tend to agree. They made it worse in a discriminatory way because it's a religious symbol as opposed to just remaining quiet. Thank you.
Thank you.
Any other commissioner questions for the investigator? Seeing none. Thank you, Alex.
Thank you.
So commissioners, you have heard from the parties and the investigator, and at this point, we would be looking for a motion or motions. There are two proposed findings.
I'll make a motion on both of them together that there's no reasonable grounds to believe that there was discrimination on the basis of race, which is one, and two, that there are reasonable grounds to believe that there was discrimination on the basis of religion, and conciliation should be attempted. And I'll speak to that.
I'll second that.
So it's been moved and seconded. Is there a discussion?
Yeah, I mean, I had originally, when I read this case, I said, wait a minute, he doesn't do anything about his religious practice until April after signing a lease in May. And there's all this business about the trailer. But the mezuzah and the damage to the door frame is truly trivial. I mean, I agree that became part of the motivation, and that they did change their, they thought that confirmed their ability to end this tenancy by saying, oh, that's another violation and you should be out immediately. And that the motivation for doing that was an impermissible basis on religion.
Any other discussion from commissioners on the pending motion? Seeing none. So the motion is to find no reasonable grounds to believe that unlawful discrimination occurred on the basis of race or color, and to find reasonable grounds to believe that unlawful discrimination occurred on the basis of religion. So if you say yes, you are in agreement with those findings. Commissioner Whitworth.
Yes.
Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner Dusant.
Yes.
Commissioner O'Brien.
Yes.
So the findings are no reasonable grounds on race and color, and reasonable grounds on the basis of religion. The commission will send parties and attorneys a letter confirming that and inviting them to participate in conciliation. Thank you all for being here today. And at that point, we'll move on to our last case of the day.
Thank you.
Which is H21-0257AC, Angela Carey v. Kimberly Radcliffe and CB Matson, Inc. This is a reasonable grounds recommendation. So we would like to hear from the respondent first. Is there anybody here for the respondents?
Yes, good afternoon. David Van Bars for respondent CB Matson, Inc.
So just to clarify, Mr. Van Bars, you are not representing Ms. Radcliffe. Is that accurate?
That is accurate.
Okay. Go ahead. You've got 10 minutes.
Thank you. There are two questions for the commissioners to decide here. The first is whether the actions of Radcliffe were so severe or pervasive as to create a hostile housing environment. As I noted, I am not here to argue her case. However, you must find that it was a hostile housing environment created by Ms. Radcliffe before you need to address the second question, which is whether CB Matson, Inc. has any liability for her actions. Ms. Carey and a number of other tenants made numerous complaints about Ms. Radcliffe's behavior. Only one of those complaints by Ms. Carey and her friend were related to her sexual orientation. These two incidents occurred 2 months apart during the over 2-year period that Ms. Ratcliffe lived at the property. Ms. Carey stated that the two incidents of homophobic name calling were not the most troubling incidents as far as she was concerned. She was far more concerned with firearms on the property and the actions of Ratcliffe's boyfriend, actions which were addressed by Mattson with its no trespass order against him. I cited in our response a number of cases and quotations from those cases that isolated and trivial actions do not rise to the level of severe or pervasive enough to warrant a finding of hostile housing environment. Again, I'm not here to argue her case, but you need to make that finding first. That brings us to the second question, and that is whether C.B. Mattson is responsible for the actions of Ms. Ratcliffe. The investigator's reasoning for finding that Ms. Carey established her claim against my client is based on two things. One, they did not immediately send a warning notice to Ratcliffe after the March incident. And two, they did not specifically mention the homophobic slurs in the warning notice they gave to her in May. This case is unlike the employment cases and the two housing cases cited in the report. In the two housing cases, the offensive conduct was alleged to have been committed by the owner's or manager's employee and not by another tenant. The standard for imposing liability on Mattson set out by the investigator is based on the facts in those cases and not on what actually happened here. The statement in the report that, quote, Mattson can avoid liability by showing that it took immediate and appropriate corrective action, close quote, is not a quote from the case cited and is not an accurate statement of what the court said. They actually held that conduct is imputable to the landlord if the landlord, quote, took no effectual correct action to correct the situation, close quote. Again, that case involved action by the management company's employee, not by another tenant. And it did not shift the burden to the landlord. A case that was not cited in the report that I subsequently found is a case more directly on point. And that is Francis v. Kings Park Manor and Raymond Endress, 992 F. 3rd 67. A March 2021 decision by the U.S. Court of Appeals, Second Circuit. In that case, Mr. Francis, a black man, lived in an apartment at Kings Park Manor. On approximately 8 occasions between February and September of 2012, a fellow tenant verbally attacked and otherwise attempted to intimidate him by making racist insults and at least one death threat. Francis wrote 3 certified letters to Kings Park Manor in which he recounted the tenant's behavior. He alleged that the landlord did not investigate or intervene and claimed that the owner expressly directed the property manager, quote, not to get involved, close quote. In dismissing his claim, the court stated, quote, the principal question presented to the court is the following. Does a plaintiff state a claim under the Fair Housing Act of 1968 for intentional discrimination by alleging that his landlord failed to respond to reports of race-based harassment by a fellow tenant? We answer this question in the negative. We think landlords typically do not and therefore cannot be presumed to exercise the degree of control over tenants that would be necessary to impose liability under the FHA for tenant-on-tenant harassment, close quote. The court held that when plaintiff brings a claim under the FHA that does not rest on direct evidence of a landlord's discrimination, he must allege some facts to support a finding that the housing provider was motivated by discriminatory intent. Because there was no direct evidence that Mr. Francis's landlord was motivated by racial animus, Francis argued that his allegations established that the landlord intentionally discriminated against him under a deliberate indifference theory of liability. The court stated that that theory of liability had been applied almost exclusively in custodial environments, such as public schools and prisons, where there is both substantial control over the context in which harassment occurs and a custodial power over the harasser, permitting a degree of supervision and control that could not be exercised over free adults. Francis argued that a landlord may be held liable for intentional discrimination if the landlord ignored the known discriminatory harassment of a third party. That is the argument that is being made here. The court held that Francis failed to state a claim because his complaint provided no factual basis to infer that the landlord had substantial control over the other tenant and the context in which the known harassment occurred. Quote, nor can such control be reasonably presumed to exist in the typically arm's length relationship between landlord and tenant, unlike the custodial environments of schools and prisons. The typical powers of a landlord over a tenant, such as the power to evict, do not establish the substantial control necessary to state a deliberate indifference claim under the FHA, close quote. Finally, the court distinguished landlord-tenant cases from employment cases, stating, quote, a landlord's control over tenants and their premises is typically far less than an employer's control over employees and their workspaces, close quote. The facts in this case are far less damning than the facts in Francis. The frequency of the incidents is fewer and far more isolated. Mattson did take some action against Ratcliffe, including several warning letters for her various lease violations, issuing a no trespass notice against her boyfriend and barring him from the property, providing Ms. Carey with a letter to assist her in her defense of the protection from harassment case, referring Ms. Carey and her friend to the agency, and filing and pursuing an eviction action against Ms. Ratcliffe. Despite these differences, the court still dismissed Francis's complaint against his landlord because of the stated legal principles, which are exactly the same here. You must find that there are no reasonable grounds to believe that C.B. Mattson discriminated against Angela Carey on the basis of sexual orientation. There is no direct evidence of discriminatory action by C.B. Mattson or any of its employees. There is no direct evidence that any action it took or didn't take was motivated by discriminatory intent. And as the Francis case decided, the deliberate indifference theory cannot be used to impute liability on Mattson absent a showing that it has the type of control over Ratcliffe that an employer would have over its employee, or which a school would have over a student. There is no evidence to suggest that C.B. Mattson had the necessary substantial control over Ratcliffe or the context in which the harassment occurred. Thank you.
Thank you, Mr. Van Bars. Before we move on, just a second. Any questions from commissioners for Mr. Van Bars? I see one hand, Commissioner Ashby.
Attorney Van Bars, the case that you just cited extensively from the Francis case, that of course, I guess I haven't read that. You shared a great deal of it with us, and I appreciate that. But I picked up on something that I'm wondering if I'm wrong. Didn't that case deal with an attempt to impose liability on the landlord for an intentional discrimination situation?
The ruling was that there was no intentional discrimination alleged by Mr. Francis. So his argument was that it was the failure to act that implies the discrimination. And that's what the court was deciding, that landlords don't have the type of control that schools have, or prisons have, or employers have over employees or students or prisoners. They can't just go and tell the tenant not to do what they're doing.
So, but I think I understand you to be saying that Francis in that case asked the court to impute intentional discrimination on the landlord by virtue of this reckless indifference standard. That's different though than in this instance, the complainant is asking the landlord for there to be liability because of a failure to correct a hostile environment situation. Am I wrong to distinguish the case you cite from this case that way?
Yes, I believe so. The argument made by Francis was that the hostile environment created by his neighbor against him was the responsibility of the landlord because they didn't do anything to stop it. And the court said, in effect, they don't have a responsibility to stop it because they don't have the control over a tenant that the other situations would have in the employer, the prison, the school. And unless there's a showing that it's some other type of housing than your typical apartment and property manager, there is no such control. And without that control, the landlord can't be held responsible.
Okay, thank you.
Commissioner David?
Attorney Van Bars, you said that the landlord can't just go and tell the tenant to change the behavior. The allegation here and the facts seem to suggest that the behavior is outrageous and pervasive, and the landlord did nothing. And the phrase deliberate indifference seems to be totally appropriate. The landlord has the power eventually and the responsibility to try to protect all tenants and ensure quiet enjoyment of the premises. And he does nothing. How do you respond to that?
Well, that's not accurate. There was one instance alleged in March of 2021 where these homophobic slurs were directed at Ms. Carey and her friend, and that CB Mattson did not respond to. They did respond in May when they received that second complaint. My client's employee stated that she did not recall receiving the specific complaint in March. When they did get the second complaint, they referred them to the agency. They gave Ms. Ratcliffe a notice, and that notice was given in accordance with the federal regulations governing this property and with the lease requirements. They gave several other notices to Ms. Ratcliffe for other violations, none of which were related to Ms. Carey's sexual orientation, but they have responded consistently, except for that one instance in March where the employee did not recall being told the specifics of the complaint.
Commissioner David, you all set? Okay, he's got a thumbs up saying he's all set. Other commissioner questions for Mr. Van Bars? Seeing none. I want to point out that Respondent Ratcliffe, is there anybody here for Respondent Ratcliffe? She did not submit an objection to the proposed finding against her. But I just want to ask if she is here or someone on her behalf is here. Okay. In that case, we turn to Ms. Carey, who did not submit anything in writing, but she's allowed to rebut the comments of the party that did submit an objection. Ms. Carey, you have 10 minutes.
Thank you. Good afternoon. I'm Angela Carey, and I am not a lawyer, so bear with me. Trying to catch up with everything here. I want to say that almost 9 months has gone by since the first allegation in March. And if I'm correct about the investigator's report, there was no verbal or written warning on the homophobic comments. I think they're saying that there was a written one in May. I believe the investigator's report said there wasn't. So to this date today, it was not addressed to her at all. As far as back in March, the housing services manager said that she recalled that. I submitted proof that there was 3 to 4 phone calls to her. That's in the investigator's report. I'm alleging because they didn't act in March, it escalated from being a dyke and a pervert to her testifying in open court in front of people and her affidavit to the court that I was trying to kidnap and steal her child. 10 days went by between the March 22nd and the April 1st order put on me against me. When I was referring to the guns and the drugs, that was about my physical safety and everything leading up to that. And you add the gun in the premises and the drugs. And yes, I was scared. That does make me scared. There's a lot of inconsistencies and half-truths. I found it very disturbing that it seemed like on the last page he was defending her. Page 6, that they didn't get her version of what happened. She had more than ample opportunity. She chose not to. And I really take offense to the 2 incidents where it's quoted 2 small incidents of name calling. It wasn't that. I mean, when she's standing out in front of 24 apartments, calling me a pervert, a dyke, a kidnapper, that raises the bar for me. That actually the sheriff's department told me that that he could have done something about that if the court ruled against me. Trying to go through all my notes here. I'm reading right off the site that says, when the harasser is a co-tenant, a landlord or manager is generally liable if he or she knew or should have known that the harassment and failed to take immediate appropriate action to stop it. I don't consider 9 months to be immediate or appropriate action. I'm basing pretty much my whole case on that. In the investigator's report, I agree 100% in what she said. She said it very accurately. And I'll take any questions.
Thank you. Just make a note. Any questions for Ms. Carey from commissioners? I do not see any. I will just note that the investigators' pronouns are they and them. So at this point, respondent has used, oh no, I take that back. Mr. Van Bars has 30 seconds left. Mr. Van Bars, if you wish to use them, you have 30 seconds left.
Thank you. I don't know which site Ms. Carey was reading from, but the case I cited to you is a United States Court of Appeals Second Circuit decision from March of 2021, holding that landlords do not have the necessary control over tenants, absent some extenuating circumstances which do not exist here, in order to hold them liable for the harassment actions of another tenant against a complainant such as Ms. Carey. Thank you.
Commissioners, any follow-up for, I see you, Commissioner Ashby, for Mr. Van Bars. Commissioner Ashby?
Attorney Van Bars, I took the opportunity to review the case you cite, and I guess I'd direct your attention at some point. We don't need to do this exercise today. To footnotes 29 and 30 in that case, it's pretty clearly the case that that case you referenced, the Francis case, is brought under the Fair Housing Act, which has a significantly different standard than the one that we're presented with here today. And the footnotes reflect that that is in fact a case involving an attempt to impute intentional discrimination of the landlord, which is not what is being attempted here, nor found by the investigator, nor required under Maine law for a complainant to make out a case. I mean, you can respond to this, but you may not have that case in front of you, but I see a significant distinction between the case you cite and the one we're here discussing today.
Without getting into the specifics of that case, I just don't see how one instance of not serving a notice can equate to my client not doing anything. Now, the report and Ms. Carey both focused on the fact that the May notice given to Ms. Radcliffe did not specifically address the homophobic comments, but that was explained by my client in the interview process and by me, that they don't limit themselves in what is put into these notices so that they have more flexibility in the future to proceed with an eviction for similar types of disturbances. So again, we're talking about one instance where my client didn't do something immediately. Now, Ms. Carey talks about 9 months, but I can't tell you the situation now, but it's over. Thank you.
Any other commissioner questions for Mr. Van Bars? Seeing none. Ms. Carey, you have about, if I wrote this down correctly, which is possibly it's not right, but 6.5 minutes left. Is that possible? But you're muted right now.
Can you hear me now?
Yes.
Thank you. I was just reading again under the HUD rule. Hostile environment harassment occurs when a housing provider subjects a person to severe unwelcome conduct and interferes with the person's access to enjoyment of housing. I mean, I believe I proved that against Radcliffe. And I believe I have also proven that CB Mattson has done nothing about my complaint. They may have taken other steps about other things she was doing, but it had nothing at all to do with what I was talking about. The way I look at it, you know, I've got the investigator's report. I've been part of this thing, you know, back and forth. In my eyes, the truth never changes. And every time they speak, it just seems like this story changes. And I have nothing else. Thank you.
Thank you. Any follow-up questions for Ms. Carey from commissioners? I do not see any. All right, thank you, Ms. Carey. Thank you, Mr. Van Bars. At this point, we would turn to the investigator, Investigator Thompson-Crossman.
Good afternoon. My name is Kit Thompson-Crossman. I'm the investigator assigned to this case. I apologize right off the bat for the fact that I'm wearing my outerwear. It is freezing in my office right now. I have an air vent blowing cold air directly on my head. A couple of things, and then I'll be happy to take your questions. One is, and I actually think that Ms. Carey pointed this out, the case that Attorney Van Bars is citing to is not a hostile housing environment case. It uses a different analysis than the one we're using here. So just to clarify, those were, I think Commissioner Ashby, you also pointed this out, that was about intentional discrimination. This is a hostile housing environment, whether CB Mattson is liable for the actions it took or didn't took with respect to Ms. Radcliffe's behavior. I did just want to clarify, and Ms. Carey brought this up, that Attorney Van Bars has suggested that I did not make any attempt to contact Ms. Ratcliffe. And I'm not sure why he would think that. She's CC'd on every correspondence that went out over the course of the investigation. She never provided a non-disclosure agreement, and so I couldn't send her any submissions or interview her until I had that. I mean, I could have interviewed her, but she couldn't have been part of the conference. I never heard anything back from her over the course of this investigation, but I did send her RFIs and requests for interviews and just did not have any participation. There were 2 complaints. I just want to make it clear. And if you look at page 9 and the second paragraph of the housing coordinator's interview in the addendum of my report, you'll see where she acknowledges that she did know about the March incident and she also knew about the May incident. Those 2 were both very explicitly based on complainant sexual orientation, and the second one clearly escalated. In between those, there was the protection from harassment order that Ratcliffe took out against Ms. Carey, whereas Ms. Carey stated, she said that Ms. Carey was being creepy towards her child in court, and then in the middle of the parking lot yelled at Ms. Carey and told her young child that she couldn't go outside because Ms. Carey was going to kidnap her. So the housing services coordinator was aware of both of those instances. In neither of those instances did she take any action against Ratcliffe where she indicated to Ratcliffe that it was because of the homophobic slurs that Ms. Ratcliffe was using and the things that she was implying about Ms. Carey because of her sexual orientation. As far as I can tell from the record, there was no action taken after the March incident, and there was a sort of general warning sent after the May incident, but that was it. And the eviction that was referenced was also explicitly not based on any of the things that Ms. Ratcliffe said about Ms. Carey. That was not referenced in the eviction at all, as far as I can tell from the record. Yeah, I'm happy. That's all I wanted to clarify, but I'm happy to take any questions that you have.
Thank you, Kit. Any questions from commissioners for the investigator? I do not see any. Okay, thank you, Kit. So commissioners, you've heard from the parties and from the investigator. There are 2 proposed findings here. The first one is not contested. Just to remind you of that, the proposed finding against Ms. Ratcliffe, there was no objection to that. So with that having been said, I think we need a motion or motions.
I think they should be taken separately just for the propriety of it because they're different. And so on the first one, I'll move that there's no reasonable grounds, that there are reasonable grounds to believe that respondent discriminated on the basis of sexual orientation.
Are you talking about respondent Ratcliffe?
Yes. Yes. Sorry, there's 2 respondents. Yes.
Yes.
Second.
So it's been moved and seconded to find that respondent Ratcliffe discriminated against Angela Carey on the basis of sexual orientation. Is there any discussion on that motion? Seeing none. So the motion is to find reasonable grounds against respondent Ratcliffe. If you say yes, you are in agreement with that proposed finding. Commissioner Whitworth. Oh, I couldn't hear you actually.
Sorry, yes.
Thank you. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner Dusan?
Yes.
Commissioner O'Brien?
Yes.
So that finding is reasonable grounds.
And I'll make a motion on the second one that there are reasonable grounds to believe that respondent Matheson discriminated on the basis of sexual orientation, and conciliation should be attempted on both claims.
Second.
Oh, I heard Ms. Dusan first, so I will call her the second. So it's been moved to find reasonable grounds against the respondent CB Matheson on the basis of sexual orientation discrimination. It's been seconded. Is there any discussion among commissioners?
Respondent certainly could have done something and did nothing. That's all.
Commissioner Dusan, if you were you looked like you were speaking, but I could not hear you. No, okay. Any other, Commissioner Ashby? Nope, you're just preparing. Okay. Any other discussion from commissioners? Seeing none. So the motion is to find reasonable grounds to believe C.B. Mattson discriminated against Angela Carey on the basis of sexual orientation. If you say yes, you are in agreement. I love your preparation, Commissioner Ashby, but I'm not going to get to you yet. Commissioner Whitworth.
Yes.
Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner Dusan.
Yes.
Commissioner O'Brien.
Yes.
So the finding is reasonable grounds on both portions of that case, and the commission will send a letter to the parties and counsel inviting them to participate in conciliation. And that is the end of our hearing agenda. Thank you to the parties and attorneys for being present. At this point, the commission will be going into executive session, but we need a motion to do that. That cites the proper parts of the statute. Nobody wants to be the one.
No, here I got it.
Okay, thank you, Deb.
Pursuant to 1 MRS Section 4056E, I move to go into executive session to consult with our attorney regarding pending and contemplated litigation and the legal rights and duties of the commission.
Second, we rely on you to get that, Deb.
So it's been moved and seconded to go into executive session. We're going to go one by one. Commissioner Whitworth.
Yes.
Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner Dusan.
Yes.
Commissioner O'Brien.
Yes.
Okay, so the motion passes, and for anyone who's still on here, I think it's just Ms. Carey, we're going into executive session. You're welcome to stay. We will be going off into the ether. We will come back after we have had our executive session discussion. Okay, this should magically, I'm
Just
sorry.
wanted to say thank you to everybody. Thank you very much.
Thank you, Ms. Carey. So this should magically move everyone else who's left into executive session. it's like magic. Did we have Melody before? What happened to Melody?
We did have Melody.
Did, yeah.
All right, well, that's all right. So at this point, all we need, I
Do we have
believe, is a
Julie?
motion regarding, oh, Ed. Hello,
Yes,
Ed. Yes.
I move that we authorize the Commission Counsel and the Executive Director to, now I forgot,
We're gonna enter into a
entering in-
conciliation agreement.
entering into a conciliation agreement in E190364 Bragg versus.
I'm sorry, is Commissioner Julie missing?
Oh, wait, you're right. Thank you.
We got Melanie, but not Julie.
Yeah. Oh, thank you for saying that, Jill. I did not even notice. Oh, okay. There we
There.
go. All right. Hold on. Julie, just so you know, we just had a motion by Ed to authorize Commission Counselor or the Executive Director to enter into a conciliation agreement in E190364 Bragg versus Walmart, just bringing you up to speed. So we had a motion and now we're looking for a second.
Second.
Okay, Deb. It's been moved to authorize Commission Counsel or the Executive Director to enter into a conciliation agreement in Bragg versus Walmart. I'm going to poll the commissioners one by one. If you say yes, you are in agreement. Commissioner Whitworth,
Yes.
Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner Dusan,
Yes.
Commissioner O'Brien.
Yes.
All right, so it's a deal that passes, and I believe that's all of our business today.
Sorry,
So-
I was late. Somehow I got on Netflix.
You got lost in the ether?
Netflix. It's
Oh,
tough for me to come back, I'll tell you.
Ooh, what are we
Fascinating.
watching?
I don't know yet.
better meeting than this one. Okay,
Is-
so I think,
Is there no office party with, little hot dogs wrapped in phyllo or
not
anything?
in COVID times.
You don't need a motion to adjourn, I assume.
We do not. You can just
you.
poof,
Hot dogs.
disappear.
Bye, everybody. Thank you.
Virtual hot
Thank
dogs.
Bye.
you.
Merry Christmas.
Bye.
Merry
Merry
Christmas,
Christmas,
everybody.
Or happy holidays or both.
Happy Kwanzaa.
Happy
Yeah.
Kwanzaa. Thank you.
I